missing? Oh, yeah. There you go. Thank you. Okay. Ms. Larkin, is Ms. Lothrop in the building? All right, thank you. Here she comes. All right, good morning. We're back on the record in case number CR 2023-026, State versus George Allen Kelly. The jury is absent. All counsel and defendant are present. The court sent a final draft of proposed final jury instructions to the parties last night. I did get an email that was forwarded to me from the state with certain suggested corrections or additions, and let's go through theirs. But was there anything, let's start first with the state. First of all, did you get the email from?
I did,
all right.
yes.
And other than what the state is proposing, and of course I'll hear from you as to that, but does the defense have any additions or corrections to the proposed final draft?
No, I didn't, Your Honor.
All right, so let's go through the state's comments, starting, was it page 25?
Yes, Your Honor.
All right, I haven't really had a chance to,
There were just a few typos. The first three
let me get
aren't-
there, let me get there. All right, 25, under the definition of intent inference.
I did also send the verdict forms. Did you get those, Judge, that you requested?
No, not yet, but thanks. But we've got some time to work on that. All right, so what's missing here? Intentionally or with intent to as,
Just it should say it need not be established. They're just typos. But the one that's important is really the page 30, justification and defense of premises. We're missing an or in that one. That's really critical to the definition itself.
I don't, oh, 31, page 31?
Page 30,
Page
defense of
30.
premises.
let me take a look at that.
Yeah, the defensive premises is page 31. Yeah, page 31.
Yeah, court's page 30 on the latest finals.
Mine's on page 31.
Maybe, I don't know, maybe they printed me the wrong final instructions. Let me look at the court's version.
This is what I got from Jose.
Yeah, it's on page 30. All
For
right.
me, it's on page 31, so I don't know if I have the same copy as everybody.
Did you get the one we sent out
That's
last
the one I'm
night after
looking at.
5? Let's
Yeah,
Let me go in
yeah,
my
I have the right
email.
one printed.
give Ms. Larkin a copy of what you have right there. Jose? Yeah, Ms. Larkin. Make sure she's got the same. All right, so, use of force.
Yeah, that's strange. I don't know. I know.
Thank you.
So you're saying it should say defendant in lawful possession or control of the premises is justified in threat to use deadly force or in using physical force?
Yes,
Where are we?
We're on justification defense of premises on page 30.
She puts that we're looking here compared.
I'm just trying to find it here where it is.
All right, do you see that, Jose?
here,
It's threatening to use deadly physical force. Threatening to use deadly.
On page 30,
You can have these if you.
justification in defense of premises. A defendant in lawful possession or control of the premises is justified in threatening to use deadly force, or, there should be an or, in using physical force.
Yeah, okay. I see that.
and then it should say or in attempting to use physical
Or
force.
in attempting.
They're all highlighted in yellow and in red in my emails, Your Honor,
All right.
to Jose.
Do you see that? All right, now, we can either just either write that in on all the copies to go to the jurors or run off another page of this. Why don't you make those corrections, okay? And run off another page of this, and we'll discuss the other objections or suggestions that the state have in the meantime, okay? And then we'll just rip this page out and put a new page 30 in. All right. Is there any objection to that change from the state, from the
No,
defense?
Judge.
Sorry. All right. You understand what I'm saying? Yes. Okay. All right. So you work on that. Don't worry about whatever else we're discussing right now until I tell you that there's something else to do. Okay. So we're working on that typographical correction, but in the meantime, we'll go on the record, all right, with the court reporter. All right, we're now on the record with the court reporter in CR 2023-026 State versus Kelly. As I've said, counsel and defendant are present. Beginning with yesterday afternoon and into the late afternoon, the court had an informal jury instruction conference with counsel and the defendant present. We had extensive discussions about the jury instructions, and the court has now prepared a final set of jury instructions. I've made the corrections to some typographical errors and words that were missing with respect to the instruction on page 30, which is defense justification in defense of premises. We're going to make those changes to add the word or, and in changing the word attempted to attempting, as suggested. Now, does the state wish to make an additional record as to the final instructions?
Yes, Your Honor.
On the record.
Yes, Your Honor. First of all, the state emailed the suggested changes to the court's JAA and to defense last night. I have copies of those. I'd like to make them part of the record. But the corrections are to the definition of intent, inference, the definition of recklessly, reckless disregard, the definition of justification for self-defense on page 26. On page 30, the instruction regarding justification in self-defense, which the court has just indicated that you are making that correction. In addition, the state has requested an edit to the criminal trespass instruction to delete or in a fenced residential yard from that instruction. The reason for that request, and also to remove the definition of fenced residential yard, the reason for that request is that in the justification for defense of premises, the only covered premises is a residence. And so for that reason, the state believes that this portion of criminal trespass is irrelevant and would be misleading to the jury. So the state is asking that that be removed. In addition, the state requests an additional instruction for disorderly conduct with a deadly weapon, and that is because of the portion of the instruction the court is proposing to offer that indicates a person does not have to retreat, except they do have a duty to retreat if they're engaged in illegal activity. It's the state's position that when Mr. Kelly discharged his weapon, he was engaging in disorderly conduct with a deadly weapon, and that would negate his lack of a duty to retreat. Finally, Your Honor, the state emailed this morning, well, and not finally, I do have some other instructions I want to talk about. But so with respect to instruction number 1 on the duty of jury, the state requests the Raji on that and objects to the court's changes. Then with respect to the justification defenses, oh, I'm sorry, let's start first with court's instruction on page 19, evidence for a limited purpose. The state believes that based on what occurred during the trial, 2 statements are necessary in addition to the paragraph that the court proposes in number 19. The state's suggesting that the court add During the trial, the court allowed questioning of Detective Rodriguez regarding a prior statement of witness Daniel Ramirez for a limited purpose. Testimony regarding the prior statement of Daniel Ramirez was admitted only for the limited purpose of challenging the adequacy of the state's investigation. The prior statement of Daniel Ramirez offered through the testimony of Detective Rodriguez may be considered solely for that limited purpose and may not be considered for any other purpose. Similarly, during the trial, the court allowed questioning of several witnesses regarding a prior statement of an individual calling himself Miguel and of an individual named Ramon Aron Felix Gonzalez for a limited purpose. Testimony regarding the prior statements of Miguel and Ramon were admitted only for the limited purpose of challenging the adequacy of the state's investigation. The prior statements of Miguel and Ramon offered through the testimony of those witnesses may be considered solely for that limited purpose and may not be considered for any other purpose. I have those in writing, Your Honor, and I would ask to submit them to the court. The reason that the state is asking for those instructions is that the court did not instruct specifically with respect to Detective Rodriguez at the time, and whether the state requested it at that time is irrelevant. The state's entitled to the instruction, and we're asking for that instruction now. In addition, the state asked to submit the entirety of the statements pursuant to Escalante Orozco and the Prazerfong case, and the state has been prejudiced by the fact that the entire statements were not allowed in. So at a minimum, the state is asking that the court provide this limited purpose instruction with respect to those statements in this case. With respect to the justification defenses, let me make sure I didn't miss anything. And Your Honor, the state believes that without these specific limited purpose instructions, the state will be prejudiced. We believe that it's confusing to the jury what the purpose of allowing those statements were, particularly without the context of the entire statements that the state asked to offer in this case. And so for that reason, the state believes that the specific evidence for limited purpose instructions as to those three statements is critical and necessary to the state's case. Next, Your Honor, with respect to the court's proposed justification defenses instructions. First, the state's overall objection to all of the 5 instructions on justification defenses proposed by the court is that they are duplicative, that they place undue emphasis on these defenses because they are so duplicative and repetitive, and they are confusing in the way that they are presented. Starting first with page 26 and the justification use of physical force instruction, that instruction is completely contained in the justification for self-defense instruction, which is beneath it. So it is completely duplicative. There is no purpose for adding that instruction twice, except to unduly emphasize the defenses. Next, Your Honor, with respect to the self-defense, use of deadly force in self-defense, that instruction is appropriate. However, the instruction regarding self-defense, use of physical force is not appropriate because there are no facts in this case that were elicited during this trial that even offer a scintilla of evidence that there was physical force used in this case. There is only the use of deadly force. Next, Your Honor, defense of a third person, that instruction is offered at page 29, and that instruction also lacks any physical or any factual basis during this trial. There's no evidence in this case at all to support an instruction for a defense of third persons. Mrs. Kelly was inside the residence at all times. There was only one shot that was ever even alleged by any party, and that only party that ever offered any evidence regarding another shot was Mr. Kelly. The circumstances under which it were offered do not support a defensive third-person instruction. Next, Your Honor, there is a defensive premises instruction. And pursuant to State versus Hussain, Hussain, 189 Arizona, 336, the defensive premises instruction, when the self-defense instructions and the defensive third-person instructions have already been offered, makes the defensive premises instructions duplicative and unnecessary. In addition, Your Honor, I want to add with respect to defensive third persons that the State versus Level case 97 Arizona 269, which has been a case that's been around since 1965, indicates that that is not appropriate for the facts of this case. Also, Your Honor, the state believes that the instruction justification in defensive premises is inadequate in this case because in a opinion that the state is offering solely pursuant to the Supreme Court rule that allows you to cite to unpublished opinions, it's the State versus Button case 2019 Westlaw 439823 at paragraph 4. Defensive premises is limited and a person may only use deadly force in the defense of himself or a third person. The way that this instruction is written does not make that clear, that the only time you get to use defensive premises as a defense is if you're defending yourself or a third person. That's why the Hussain case says that this instruction, when you've already offered the other two instructions, is completely duplicative and unnecessary. And the state believes that that prejudices the state by the duplication of the same instructions over and over and over again in this case. May I just have a second to look around and make sure I didn't leave anything out? Anything I missed? Your Honor, and I would offer our written emails and requested corrections to be made as part of the record, including what I just read into the record with respect to the limited purpose instruction.
Can you go get Jose, please? I'm sorry. You finished?
Yes.
All right, thank you very much. Yeah, you can make that, those will be filed and made part of the court record.
Thank you.
You can give those to the clerk right now. What is the defense position about the objections, suggestions, and corrections that are proposed by the state?
That are contained in the email, I guess I'll start there. I'm okay with the typos that they're pointing out. They are requesting that they delete or in a fenced residential yard.
Do you just tell me the areas, if there are any, of agreement with them?
Okay.
And we'll start from there. How about that?
Sure. Their first item is page 25. There's a typo on intent inference. I'm okay with making that change. Then also on page 25.
And which one was that? Intentionally with intent to?
Intent inference, Your Honor.
Oh, it need not be established by censor. There's an it missing?
Yes.
Okay.
Yes. Then page 25, definition of recklessly or reckless disregard.
What's the correction there?
They say the risk must be of such a nature and degree that disregarding it is a gross deviation. So the risk must be, instead of a such nature, of such a nature, and degree that disregarding it is a gross deviation.
Okay. All right. Jose's already made that correction,
Okay,
all right? And he made the other one, too.
all right. Page 26, there's a typo in justification for self-defense, number 1. A reasonable person in the situation would have believed that physical force was immediately instead of immediate.
Okay, he made that correction.
All right. And then I think the one on page 30 was already made as well.
All right.
So on page 30, criminal trespass, the state is requesting that the court cross out "or in a fenced residential yard." I don't know why they would cross that out. According to Mr. Kelly and Wanda, they saw individuals who were running in the paddock area, which is immediately adjacent to their residence and is fenced.
All right,
And
I'm
that-
just asking, I'm asking for your areas of agreement with them to start. off
Okay,
with.
okay.
But I understand what you're doing, but I'm just.
Okay, I'm just trying to go in order. Do you want me to skip over the things I disagree with and just go to the things we agree with? Okay.
Correct.
In which case, that is it.
All right, so the bailiff, my judicial assistant, has made those corrections to pages 25, 26, and 30. So he's running off copies of those pages so that they can, the pages that need to be corrected can be removed. We'll insert those pages, and then we'll have a full set of instructions for each of the jurors. Should just take a few minutes. Other than that, the state's requests are noted for the record and are all denied.
Your Honor, can my client and I share a actual copy of the new revised?
Right, he's running off a bunch of copies,
Okay,
so
wonderful.
hopefully
Thank you.
there should be enough for everyone, but yes. All right, so we'll get that copied off, we'll get those pages substituted in, and we'll be ready to bring in the jury and do final jury instructions, and we'll begin closing arguments.
We don't want to do the verdict forms, Judge?
I'm going to be working on that. We don't need the verdict form until we discharge the jury to go and start the deliberating, so I'll be working on that during the closing arguments. But
Okay.
if you emailed it to him or give it to the judicial assistant, and
Yeah, I have
he'll
multiple
pass it up to me.
copies
And
if
I did
anyone-
some research on that last night as well.
Okay.
All right, so, well, here he is.
Oh, Your Honor, I did have a record to make with
Hold on one
respect to that,
second.
too.
Hold on one second. So how are we doing? What are we doing now? All right, do you have somebody to help you? Just, yeah, because what do you have, like 20 copies of them, right?
Yes.
All right. Yes, go ahead.
The record I had to make on that is that the defense requested that the jury make the determination of dangerous nature during the aggravation phase of the trial. We didn't object to that, and I just want to make sure that if there's any issue with respect to that, it's waived by the defense, because I did not include that in the verdict forms for that specific reason. If that issue is not waived by the defense, we'll need to add that back in, the interrogatory with respect to dangerous offense.
All right, why don't you folks talk about that amongst yourselves while we're just finishing these, getting these instructions prepared, and then,
Would you like the verdict form?
yes, I would. All right, thanks. Well, they're working on that, folks, so hopefully it'll just be a few minutes, we'll be able to get going. We'll be in recess until we have the jury instructions ready to go.
Please rise.
Thank you, you can be seated. All right, what we're going to do, we're back on the record. Everyone's present except the jury. What we're going to do is we'll prepare a set of final instructions that'll go to the jury that have those corrections on pages 25, 26, and 30. But as I read them, I'll make the corrections orally and inform the jury what it should say on those particular pages. Let me just make sure I have that written in. But the final instructions will be a corrected set of instructions. And that'll save time. All right, so 25, intent inference should say it need not be, right? And then on, let's see, what was the correction on 26 again? 26,
The other 25 was under recklessly, Your Honor, and it's the second sentence. The risk must be of such a nature and degree that disregarding it is a gross deviation.
Recklessly means the defendant is aware of and consciously disregards a substantial and justifiable risk. The risk must be of such a nature, right? All right.
And then 26, did you want that one?
Yeah, what's 26?
It's under the justification for self-defense. And instead of immediate on number 1, in the second sentence, it should say immediately.
All right. And then 30, right, or in attempting. All right, very well. All right, let's pass out the final and jury instructions, give them to counsel and the defendant, and put one on each of the jurors' chairs. Thank you.
That one, you'll know. Oh, yeah, sure. I don't need to see. Hey, Jorge. Can we flip the screen so he can see it when he's presenting?
I haven't, thanks.
Can we turn it? So that he can see it when he's presenting?
Can I rotate that screen?
So he can see it? We just didn't want to ruin your technology.
All right, let's bring in the jury.
You want your screen too? That's okay. Share the screen. They do that. Have you checked to make sure it's in the presenter view? Did you try it? Can we test the screen, Valeria? Can we test his screen?
Who's going to do the closings for the defense? All right.
Mr. Jetty, did you want to project what you have on your screen onto the gallery and this? I will be, yes. Okay. Yes. But is that what you're ordering?
You're a smart person. You can figure it out.
Please rise.
Thank you. Please be seated. The record will show the presence of all the jurors, counsel, and the defendant. Ladies and gentlemen of the jury, thank you for your patience. Obviously, my projections yesterday about how long this would take us didn't turn out to be accurate. So thank you for your patience. But we are now ready to proceed with the final jury instructions. Each of you has a copy of the final and jury instructions. There's a couple of typographical errors that I'll point out, I think, as we go along. You're welcome to follow in the instructions as I read aloud, or just listen to what I have to say, whatever you're most comfortable with. You will have one set of these final jury instructions with you in the jury delivery room jury room when you are excused to deliberate. So you'll have a set of these as well. All right, so the first page is a cover sheet with the caption of the case. Page 2 is where we start. It's called Duty of Jury. It is your duty as a juror to decide this case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide the case. It is your duty to determine what the facts are in the case. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as the jurors, are the sole judges of the facts. You must consider all of these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. The state has charged the defendant with certain crimes. A charge is not evidence against the defendant. You must not think that the defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means the state must prove each element of the charges beyond a reasonable doubt. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. We should be on the top of page 5. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means that the state must prove each element of each charge beyond a reasonable doubt. In civil cases, this is not, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based upon your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. There are 3 standards of proof that we use in our legal system. 1, preponderance of the evidence. 2, clear and convincing evidence. And 3, beyond a reasonable doubt. Preponderance of the evidence is a party having the burden of proof by a preponderance of the evidence must persuade you by the evidence that the claim or fact is more probable true than not true. This means that the evidence that favors a party outweighs the opposing evidence. Clear and convincing evidence, a party having the burden of proof by clear and convincing evidence must persuade you by the evidence that a fact or a claim is highly probable. The standard is higher than the standard for proof beyond. The standard is higher than the standard for proof by a preponderance of the evidence, but it is lower than the standard for proof beyond a reasonable doubt. Now we come to the standard in this case, which is proof beyond a reasonable doubt. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means that the state must prove each element of each charge beyond a reasonable doubt. Proof beyond a reasonable doubt is proof by the evidence that leaves you firmly convinced of the defendant's guilt. This standard is higher than the standard for either proof by a preponderance of the evidence or by proof by clear and convincing evidence. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based upon your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crimes charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. You must decide whether the defendant is guilty or not guilty by determining what the facts are in the case. and applying these jury instructions, you must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. You are to determine what the facts in the case are from the evidence produced in court. If an objection to a question was sustained, you must disregard the question, and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. The state must prove guilt beyond a reasonable doubt based upon the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. In their opening statements and in their closing arguments, the lawyers have and will talk to you about the law and the evidence. What the lawyers say is not evidence, but it may help you to understand the law and the evidence. Some of the exhibits that have been admitted into evidence have portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to decide the importance to be given to the evidence regardless of whether it is direct or circumstantial. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness has testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before the trial, or by other evidence, and the reasonableness of the witness's testimony when considered in the light of all of the other evidence. Consider all of the evidence in the light of your reason, common sense, and your experience. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all of the other evidence in this case. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant, acting with the advice of an attorney. You must not let this choice affect your deliberations in any way. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. You have heard evidence that a witness has previously been convicted of a criminal defense. You may consider this evidence only as it may affect the witness's believability. During the trial, the court admitted evidence for certain limited purposes. In connection with that evidence, the court gave you limiting instructions. That evidence was admitted only for the limited purpose that the court stated at the time, and therefore you must consider it only for that limited purpose and not for any other purpose. Evidence of other acts that have not been charged has been presented. You may consider these acts only if you find that the state has proved by clear and convincing evidence that the defendant committed these acts. You may consider these acts to establish the defendant's preparation. You must not consider these acts to determine the defendant's character or a character trait and therefore committed the charged offense. Each count charges a separate and distinct offense. You must decide each count separately on the evidence with the law applicable to it, uninfluenced by your decision on any other count. You may find that the state has proved beyond a reasonable doubt all, some, or none of the charged offenses. Your finding for each count must be stated in a separate verdict. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdicts. The crime charged of second-degree murder requires proof of one of the following. One, the defendant intentionally caused the death of Gabrielle Quen Butamea, thereafter abbreviated as GCB. Or two, the defendant caused the death of GCB by conduct which the defendant knew would cause death or serious physical injury. Or three, under circumstances manifesting extreme indifference to human life, the defendant recklessly engaged in conduct that created a grave risk of death and thereby caused the death of GCB. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. The crime of second-degree murder, which I just described, includes the lesser offense of manslaughter and the lesser offense of negligent homicide. So now we're going to discuss the elements of the offense of those two additional lesser included offenses. Manslaughter. You may consider the lesser offense of manslaughter if either, one, you find the defendant not guilty of second-degree murder, or, after a full and careful consideration of the facts, you cannot agree on whether to find the defendant guilty or not guilty of second-degree murder. Reckless manslaughter requires proof that the defendant recklessly caused the death of another person. Reckless manslaughter, the crime of manslaughter, requires proof that the defendant caused the death of another person and was aware of and showed a conscious disregard of a substantial and unjustifiable risk of death. The risk must be such that disregarding it was a gross deviation from the standard of conduct that a reasonable person would observe in the situation. Second-degree murder and manslaughter may both result from recklessness. The difference is that the culpable recklessness involved in manslaughter is less than the culpable recklessness involved in second-degree murder. We should be at the top of page 24. If you determine that the defendant is guilty of either second-degree murder or manslaughter, but you have a reasonable doubt as to which it was, you must find the defendant guilty of manslaughter. You must unanimously agree that the state has proven manslaughter beyond a reasonable doubt before you may find the defendant guilty of manslaughter. The other lesser included offense is negligent homicide. Negligent homicide. You may consider the lesser offense of negligent homicide if either, one, you find the defendant not guilty of second-degree murder and not guilty of manslaughter. Or, after a full and careful deliberation of the facts, you cannot agree on whether to find the defendant guilty or not guilty of second-degree murder or manslaughter. The crime of negligent homicide requires proof that the defendant, 1, caused the death of another person, and 2, failed to recognize a substantial and unjustifiable risk of causing the death of another person. The risk must be of such a nature and degree that the failure to perceive it is a gross deviation from what a reasonable person would observe in the situation. The distinction between manslaughter and negligent homicide is this. For manslaughter, the defendant must have been aware of a substantial risk and consciously disregarded that risk that his conduct would cause death. Negligent homicide only requires that the defendant failed to recognize the risk. If you determine that the defendant is guilty of either manslaughter or negligent homicide, but you have a reasonable doubt as to which it was, you must find the defendant guilty of negligent homicide. You cannot find the defendant guilty of any lesser included offense unless you find the state has proved each element of the lesser included offense beyond a reasonable doubt. Now we go to, I think it's count 2 of the information, the second charge, which is aggravated assault. The crime of aggravated assault requires proof of the following. 1, that the defendant committed an assault on Daniel Ramirez. And 2, the assault was aggravated by the following factor, that the defendant used a deadly weapon or dangerous instrument during the assault. Now, the definition of assault is as follows. The crime of assault requires the proof that the defendant intentionally placed Daniel Ramirez in reasonable apprehension of imminent physical injury. Now we have some definitions of some of the terms used in defining the elements of the offense. Knowingly. Knowingly means that a defendant acted with awareness of or belief in the existence of conduct or circumstances constituting an offense. It does not mean that a defendant must have known that the conduct is forbidden by law. Intentionally or with intent to, as used in these instructions, means that a defendant's objective is to cause the results or to engage in that conduct. Intent and an inference, intent may be inferred from all the facts and circumstances disclosed by the evidence. There should be a word it, and your final instructions will read, it need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Recklessly or reckless disregard means that a defendant is aware of and consciously disregards a substantial and unjustifiable risk that the conduct will result in death. The risk must be of such a nature and degree that disregarding it is a gross deviation from what a reasonable person would do in that situation. Physical force means force used upon or directed towards the body of another person, and this includes confinement, but does not include deadly physical force. Physical injury means the impairment of a physical condition. A deadly weapon means anything designed for lethal use, including a firearm. Deadly physical force means either, 1, force which is used with the purpose of causing death or serious physical injury, or 2, force which is used, or 2, force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Justification, use of physical force. A defendant is justified in using physical force as follows. The use or threat of physical force or deadly physical force is justified only while the use or threat of physical force or deadly physical force is justified only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that imminent physical danger appeared to be present.
Immediate physical danger, not imminent.
Okay, thank you. Let me correct that. If I misspoke, I'll start at that paragraph again. Thank you. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. Actual danger is not necessary to justify the use of physical force or deadly physical force. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. A defendant is justified in using or threatening physical force in self-defense if the following two conditions existed. One, a reasonable person in the situation would have believed that physical force was, and that should say, immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful physical force. And two, the defendant used or threatened no more physical force than would have been necessary to a reasonable person in the situation. A defendant may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of physical force or deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. Actual danger is not necessary to justify the use of physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that physical force was immediately necessary to protect against another's use or attempted use or threatened use or apparent attempted use or apparent threatened use of unlawful physical force, or you must measure the defendant's belief against what a reasonable person in the situation would have believed. The threat or use of physical force is not justified, one, in response to verbal provocation alone, two, to resist an arrest the defendant knew or should have known was being made by a peace officer or by a person acting in a peace officer's presence, or at the peace officer's direction, whether the arrest was lawful or unlawful, unless the physical force used by a peace officer exceeded that allowed by law. Or three, the defendant provoked the other's use of unlawful physical force, unless the defendant withdrew from the encounter or clearly communicated to the other person the defendant's intent to withdraw, reasonably believing that the defendant could not withdraw from the encounter, and B, the other person nevertheless continued or attempted to use unlawful physical force against the defendant. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. A defendant is justified in using or threatening deadly force in self-defense if the following two conditions existed. 1, a reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and 2, the defendant used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use or attempted use or threatened use or apparent attempted use or apparent threatened use of unlawful deadly physical force. You must measure the defendant's belief against what a reasonable person in the situation would have believed. A defendant has no duty to retreat before threatening or using deadly physical force in self-defense if the defendant, 1, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and 2, was not engaged in an unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. The next charge concerns justification for defense of a third person, a different person. A defendant is justified in using or threatening physical force in defense of a third person if the following two conditions existed. 1, a reasonable person in the situation would have believed that physical force was necessary to protect another's use or attempted use or apparent attempted use or threatened use of unlawful physical force against a third person. And 2, the defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in defense of a third person only to protect another's use or attempted use or apparent attempted use or threatened use of deadly physical force. Defense of a third person justifies the use or threat of physical force or deadly physical force only while the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that, 1, physical force was necessary to protect against another's use or attempted use or apparent attempted use or threatened use of unlawful physical force against a third person, or 2, deadly physical force was necessary to protect against another's use, attempted use, or apparent attempted use or threatened use of physical force against a third person. You must measure the defendant's belief against what a reasonable person in the situation would have believed. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, you must find the defendant not guilty of the charge. The next charge relates to justification of premises. A defendant in lawful possession or control of the premises is justified in threatening to use deadly physical force, and there it should say, or in using physical force, or in, and it should say, attempting to use physical force, or in threatening to use physical force in defense of premises, if a reasonable person in the situation would have believed it immediately necessary to prevent or terminate the commission or attempted commission of criminal trespass by another person in or upon the premises. The use of force may not be greater than reasonably necessary to prevent the attempted criminal trespass. An actual criminal trespass is not necessary to justify the use of physical force in defense of premises. A defendant is justified in defending premises if the defendant reasonably believed that a criminal trespass was being committed or attempted. You must measure the defendant's belief against what a reasonable person in the situation would have believed. The defense ends when the attempted or actual criminal trespass ends. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Now here's some additional definitions. Criminal trespass is knowingly entering in or remaining unlawfully in or on a residential structure or in a fenced residential yard. Premises means any real property and any structure, movable or immovable, permanent or temporary, adapted for both human residence and lodging, whether occupied or not. A residential structure means any structure, movable or immovable, permanent or temporary, adapted for both human residence and lodging, whether occupied or not. Fenced residential yard means a unit of real property immediately surrounding or adjacent to a residential structure and enclosed by a fence, wall, building, or similar barrier, or any combination thereof. All right, the final two instructions are instructions I'm going to give you after the closing arguments and when I send you out to deliberate. So that concludes the final instructions. Were there any corrections in the court misread, anything else other than it's been pointed out by counsel?
No, not from the state, Your Honor.
No, Your Honor.
All right, very well. So ladies and gentlemen, you put those aside. Again, you'll have corrected with those typographical errors, you'll have corrected the final instructions with you in the jury room when you retire to deliberate. And with that, the state can begin its opening closing argument. Mr. Jetty.
Thank you, Your Honor. Good morning. This is the first time I've been able to address you directly. Once again, my name is Mike Jetty, and I want to just echo what Ms. Hunley said at the beginning. We appreciate your attentiveness during the entire trial. It's been 4 weeks, so we appreciate the time and devotion you have because it's a very important duty we have here. And we'll start off by saying that I'm not going to go over every fact. I'm not. My job here is to take the wheat from the chaff here and focus in on the important things in this case. Our goal here is to simplify. So if there's a fact that I didn't cover, don't read into that. You're the deciders of the facts to apply to the law the judge just read. Okay? State v. Kelly. This occurred on January 30th of 2023. Oh, I'm sorry. Was this? The whole thing was not. I'm sorry, Lydia. That's my bad. Like I said, my job here is not to go over every fact in this case. State v. Kelly. It's an event that occurred on January 30th of 2023. Gabriel and Daniel were in the U.S. seeking the American dream. Yes, both were undocumented migrants. Both were escaping extreme poverty. Defendant sees Gabriel and Daniel running back to Mexico. Not just running back to Mexico, 115 yards from his property, beyond 2 fence lines. And they're running because earlier they found Border Patrol. The group scattered and the 2 took off. The defendant sees them beyond the 2 fence lines, 115 yards away, picks up his AK-47 that he keeps by the patio door, steps outside of that patio, on that patio door, in the patio area, and without verbal warning, without a shout, without any indication to both Gabriel and Daniel, points that weapon at these 2 men and shoots over and over and over again, 9 times. Gabriel was judged that day and sentenced to death by the defendant. It's a picture of Gabriel. And that's a picture of the AK-47, the weapon used. That weapon can fire 30 rounds in 6 seconds. You were out there. We had a jury review. I forget which week it is now. I think it was last week. And that's a view from the patio and the gravel. And this is 14 months ago. So obviously there's new growth out there. We were all out there. And you see that's an individual out there. This is the site view from the patio and gravel. You saw this picture earlier in opening. And that is Detective Barba out in the distance. Question you have to ask, is that a threat? Is that a threat to you? The answer is no, it's not a threat to the defendant. That's a picture of Gabriel in the high grass. Lights in the background of the Kelly's home. The position of the body, orientation of the body, the injury, matches up directly with the defendant's home. That's the injury wound caused by the projectile, which matches up with the defendant's home. That's a picture rolled over, Gabriel rolled over, hand clenching his chest, I've been shot, falls forward and dies. That injury breaks 3 ribs, perforates the right lung, 3 lobes of the right lung, and severs the aorta. You're not moving after severing the aorta. You're done. Life is over. It's a picture of a drone. We're going to walk through it. You saw the cones. That's estimated by Detective Bunting where the shooter was standing. We're going to go past 1 fence line. We're going to pass a 2nd fence line. This is a distance here. 115 yards. And we're going to see some red cones here where the victim's body was located. And we all stood out there on that site. Camera's going to pivot. You heard from DPS that they took a drone footage and put it on a mapping of some sort, and it gives us this GPS mapping. The blue line on the left-hand side, that's a north-south directional line. The red one, east and west. And that green line is the patio to the victim's body. And that's the orientation of the victim's body. I'm going to say it again. Matches perfectly from the patio to the victim, the orientation of the body. The defendant shot 9 times. He's been charged second-degree murder and aggravated assault with a deadly weapon. Second-degree murder, you heard from Ms. Hunley in the opening, is a unified offense. There's 3 ways to prove it. You don't have to agree on all 3 ways, but you have to agree on second-degree murder. First way, Kelly intentionally caused Gabriel's death. When you walk out on a patio and point a gun at someone and shoot 9 times, that's intent. Kelly caused Gabriel's death by conduct Kelly knew would cause the death or serious physical injury. An AK-47 is a serious weapon. It's not no play toy. And when you fire it 9 times at a human being, it's a serious activity. Third, under circumstances manifesting extreme indifference to human life, Kelly recklessly engaged in conduct that created a grave risk of death and thereby caused Gabriel's death. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. 2 men walking southbound, no danger to you, and you don't even give a warning? Hey, get off my property. Get off my property. Or just sit back and let them continue on. Facts of this case. Gabriel and Daniel were shot at. Gabriel is dead. Killed by a high-powered weapon. An AK-47 is such a weapon. Kelly wound is to the right side back. Exit wound to the chest. Consistent with the direction of the defendant's home. The defendant's words on his dispatch or BP to dispatch to officers and during Detective Ianza's interview, inconsistent. Every single time the story changed. Every single time the story changed. Daniel's words, consistent. Heard an AK-47, horse saved his life, heading southbound. I just want to repeat real quick since we're on Daniel. Daniel's the only one in this courtroom, on this hill, and likely in the city of Nogales, who's ever been shot at with an AK-47 9 times and be next to a friend who just died. So maybe, during his testimony, distance and time is a little skewed. Just maybe. But he knows it's an AK-47, he knows it's a red horse who saved him, and he's heading southbound. Defendant steps out, no verbal warning. Defendant shot his AK-47 9 times. There's shell casings found with the ejection pattern that matches what DPS forensic scientist Burnell is consistent with the ejection patterns and position orientation of the body. Once again, matches up with only one known shooter. You've heard instruction, there's also a lesser included. So if you do not find, beyond a reasonable doubt, the defendant caused second-degree murder, you can consider manslaughter. And manslaughter, as a judge read, and you'll have jury instructions, I won't spend too much time on this, but it requires proof the defendant caused the death of another person, and the defendant was aware of and showed a conscious disregard of a substantial and unjustifiable risk of death. Stepping on a patio with an AK-47, shooting at two armed men walking southbound, no danger to you. And if you don't find second-degree murder, and you don't find manslaughter, you can consider negligent homicide. Negligent homicide requires proof of the defendant caused the death of another person. The defendant failed to recognize a substantial and unjustifiable risk of causing the death of another person. Aggravated assault, second charge. Aggravated assault with a deadly weapon. The defendant committed an assault against Daniel, and the defendant used a deadly weapon, an AK-47. Assault requires defendant intentionally puts Daniel in a reasonable apprehension of imminent physical injury. Steps outside with an AK-47 and shoots that gun. And that's the horse. According to Daniel, saved his life. He recognized that horse. He identified that horse. That's the defendant's horse. And that horse was between him and the Kelly's residence. Defendant's words. I'm not admitting to anything I've done, but all those things tend to add up. And they do. Removing the wheat from the chaff here. Agent Morcell, first witness for the state. 2:30 phone call. I'm going to summarize these for you. First phone call, I'm being shot at. I'm shooting back. There are 5 people, all packs, with packs running southbound. I'm being shot at, and I'm shooting back. 5 individuals in this story. That's at 2:30 in the afternoon. 6 minutes later, defendant changes that story. I had an altercation with someone. I heard a gunshot in his direction, in my direction. Inspected his horse while they spoke. I'm going to argue he inspected his horse because he shot his gun 9 times. He wanted to make sure he didn't shoot his own horse. They were too far to tell if any of them had firearms. And that's probably the most truthful thing he says here. Because you were out there, 115 yards is pretty dang far away to see a firearm on an individual. 2:40, 10 minutes after that first phone call. And what's happening in the background with 2:30 is BP is now communicating to SO Dispatch. And SO Dispatch is doing a code 3 alert, and lights and sirens going off, and all SO people are responding to scene because to them, they think it's an active shooter. And we want law enforcement to believe, when we call them, we want them to believe the story. They're not here to second guess it. So lights and sirens are going. And 10 minutes after that phone call, respond, active shooter response. You heard testimony. The goal is number 1, preservation of life. BP locates the defendant near his barn. And you heard Agent Heredia on the stand. He appeared calm. 10 minutes after being shots fired, I'm shooting back, the defendant is calm. He's calm. He's carrying an AK-47, walking with his 2 labs. No one located on the property on a security sweep. No one. 3 p.m., defendant says people were possibly carrying rifles. Possibly now. We went from, I'm in a shootout, to too far to tell, and now maybe not, maybe so. They were 100 to 150 yards away from his property. Castaneda told the defendant that if anything like this happened again, don't do anything, call 911, stay in your house. And his response, understood it. He said, I'm going to do what he had to do to protect his property. He was conscious of the consequences. He would take responsibility for his actions. Talking to BP and SO, the defendant never admits that he shot his AK-47. We've got Border Patrol and agents on scene for an active shooter situation, and you failed to tell them that you shot your own weapon? Never told law enforcement that anyone pointed a gun at him. Didn't tell anyone. This just happened. This literally just happened. And you're not telling a single soul that people are shooting at you? Never told law enforcement he was in fear of his life. 423, he's calling. I think this is a thank you call for Agent Marcel to get a quick response to him. In this call, he says now, instead of 5 folks, we have 10 to 15, all loaded with AR-style rifles. We're getting exaggerated statement here now. 523, and this is the second wave of phone calls. That was the first wave, the active shooter call, and now we got the calls and dispatch recording related to Gabrielle's body. Jeremy, this is Alan Kelly. You need to call me immediately. This is serious. Call me immediately. I can't say more on the phone. Why can't you say more on the phone? Why can't you say more on the phone? 526, he sends that text message. 535, here comes the 4th phone call. This is worse than you can imagine. This is bad. Marcel told Kelly, call 911 and talk to SO. He never does. He never calls the SO. The SO calls him. Because Marcel does what a Border Patrol agent is supposed to do. If there's an immediate emergency, he routes a call to the local law enforcement, which is the SO. And the SO then, without him calling, calls him to find out what's going on, what's so serious, and why immediate response again. You know how shots were fired earlier? Something was possibly struck. Just say, there's a body on my property. Just say it. When Marcel asked for additional details, Kelly said, I can't tell you over the phone. Ask Marcel if this was being reported. That's a noteworthy question right there. This is that dispatch call. Do I have my microphone? Let's see if we play it.
Hello?
Hi, sir. I'm calling from the Santa Cruz County Sheriff's Office.
Yes.
Hi. I'm just calling because we received the report from Border Patrol.
Yes.
So I'm just calling to get more information. So what happened?
You're going to have to send an officer out here.
Okay, what's going on?
I can't.
I'm sorry?
It's very serious, ma'am, and I'm not going to talk over the telephone.
Okay, I understand it's serious, but I need more context in order to send a deputy.
Okay, fine. It's going to be...
Go ahead,
well,
you can talk to me. What's going on?
Yeah, I know I can talk to you, but you're responsible for what I say, and I'm responsible for what I say.
Can you give me a little context of what happened? What's going on? You told them that
I'm
you
not-
shot at
I'm-
something. What did you shoot at?
I didn't shoot at any. I haven't said I shot at anything.
Okay, well,
what-
that's what Border Patrol told us, so that's why I'm just asking you.
Yeah. Y'all guys, the Nogales Sheriff Department had 4 or 5 guys out here this afternoon investigating a Border Patrol drug running incident.
Mm-hmm.
And I don't know if I can't remember the officer's name. There was 2 gentlemen and 2 young ladies, maybe third. Do you know who I'm talking about? They came out to 100 Willer Cross Circle.
You mean for my deputies, correct?
Yeah, they were Nogales.
Yeah, I'm aware of what happened earlier.
You're aware? Okay, then they're aware of what happened, and I don't want to get you in trouble, and I don't want to get me in trouble, but I don't want to break the law or anything like that. So what I'm telling you is that we need a sheriff deputy out here, 100 Willer Cross Circle, immediately, and that's all I can say, ma'am.
Okay, is anyone hurt? I need to know, because if someone's hurt, I need to send an ambulance too.
There's no.
Okay, do you feel more comfortable talking to a deputy over the phone?
Well, in other words, okay, you know the thing. You have the right to remain silent, and anything you can,
I understand.
anything you say can and will be held against you in
understand.
a court of law. I'm not admitting to anything I've done, but all those things tend to add up, and I don't know what happened. I just know what I just saw about 15 minutes ago, and it's something that an ambulance cannot help. EMTs cannot help. There's nothing out here that can be aided by EMT or emergency services. There's
Okay, I understand you don't want to give me a lot of details, but what you are requesting an officer from me, so I just needed to know for their own safety and your safety a little bit of what's happening, what's going on.
okay. I'll put it like this: last spring, out here, there was a pickup found on East Sagebrush with a dead lady in it.
Mm-hmm.
I don't know if you knew of that or not.
Yes, sir. I'm aware of what happened.
Okay, it's a situation similar to that. How's that?
Okay.
You follow? You understand what I'm saying?
I
It's a
understand what you're
situation
saying.
exactly like that.
Okay.
And so that's going to require the sheriff to come out here.
Okay. Can you tell me a description of? Does it
No,
involve a vehicle?
I don't have a description. There's not a vehicle.
Okay.
The only thing that I was referring to in conjunction
Is
with
the
that
incident?
accident was the body.
Okay.
You got it?
Okay. All right. Okay, can I have your name?
Yes, George Kelly.
George Kelly. Okay, George, would you, if my deputy goes over there, would you take him to whatever it is
Yes,
that you
yes,
found?
yes. I have it marked. I have a flashlight on over it because it's going to be dark when he gets here probably, but I'll take it to him.
And you are sure an EMT cannot help?
I am positive. I have a medical background. An EMT cannot help.
Okay. Do you know whoever it is that you saw?
No, I do not know. I didn't say it was anybody. I just said it was a body.
Okay. All right. Okay. All right.
I'm not trying to be smart, ma'am. I'm just trying to.
I understand. You're trying to be careful, and I get that. However, I hope you understand that on my end, I have to take care of my deputies too. So I just needed a little bit more context as to why you needed a deputy to head out there.
Now you know that there is a body here.
Okay. All right. Does it look somewhat?
And it's not alive. So you asked, did you need EMT? I said no.
Okay.
I'm sure a coroner will be involved sooner or later.
I understand. George, can you tell me something? Is it discolored from somewhere?
Is it discolored?
Yes.
What does that mean?
Has it been there for a while? Can you tell?
From what? In that I only approached the body to make sure that the animal, it's not a vegetable or a mineral, the animal wasn't alive and it was not alive.
Okay.
There were no signs. There was no signs of blood. There was just an animal laying face down.
An animal?
An animal, and you know what an animal is. It's not a vegetable or a mineral.
Okay.
It's a body, and you know what I'm talking about.
I understand what you're talking about, George.
Yeah.
Okay. I'm going to send the deputy then over to your house so you can lead them over to wherever you found what it is
Okay.
you found, okay?
And now, maybe one of the deputies were out here. They know how to get here because it's 100 Willicross Circle, and it's kind of hard to find. It's a ranch right on the border. So
I have one of my deputies that responded earlier going over your way.
there you go. That's good. You do that. They know how to get here, and I'll have the gate open.
Okay. Sounds good, George. Thank you. Thank you for the information.
I appreciate your help and your patience, and I'm sorry if
No problem. I understand.
Okay.
Okay.
Bye.
Thank you.
That's a phone call SO had to make to the defendant. Defendant says it's very serious. Recap. Very serious. I can't tell. I'm not going to talk over the telephone. I don't want to get me in trouble. I'm not admitting to anything I've done, but all those things tend to add up. Deputy Lopez gets on scene. That's Exhibit 38. I'm not going to play that for you, but it's admitted into evidence. That's that recording that Deputy Lopez recorded. He says in that, quote, defendant, I have no idea, I have no idea, I have no idea. And you know, if you were me, you got no idea. You know what I'm saying? You literally shot your gun 9 times, and you've got no idea what possibly could have happened. Sergeant Rodriguez gets on scene, 6:15. Sergeant Rodriguez is the one that pronounces Gabriel dead. That's not the time of death. That's the pronouncement of death by law enforcement. No pulse, extremities are cold, but his torso was still a little warm. Importantly, there's no drag marks, blood trails, or foot traffic evidence anywhere. It appeared as though Gabriel fell where he was shot. And at this point, Sergeant Rodriguez does not know Dr. Tim's autopsy results. A severed aorta. That's a drop shot. You're going down. The entry wound lined up with the east patio of the Kelly residence. Again, entry wound and orientation lines up. And then the defendant has an interview with Detective Ainza. In that question, he says, question, did you shoot? I have no reason to believe I shot this person. Ainza, what does that mean? Defendant, it means I have no reason to believe I shot him. That's simple. Question, did you shoot? No response. No response. Detective Ainza, at this stage, has already talked to Border Patrol. He's already talked to dispatch. He's already talked to SO. So Detective Ainza has information. And during an interview, he's not going to disclose the information. He wants the defendant to talk to him. The defendant does not say he shot his weapon. And until 30 minutes into this interview, of a 50-minute interview, he finally does. And this is the interaction. Look at me. I can see it in your eyes. Defendant, I haven't said I didn't shoot. Did you shoot? No response. Towards these gentlemen. No, I did not shoot at those gentlemen. did you shoot? All Detective Ianza is trying to figure out is, did you shoot? And finally he says, yes. Then he says, I shot over their heads. Shot over their heads. He shoots in their direction, says that this time, Ianza asks if it's 100, 150 yards away. He affirms that, and he says they were armed. Remember earlier statement, too far to tell? You were out there. Defendant, I shot 100 yards over their heads. I didn't shoot at them, I shot over their heads. Anza, you shot towards the direction of their heads? Yes. Does not admit he shot his AK-47 until 30 minutes into that interview. You saw pictures of the shell casings. You're out unseen. Right next to, if I'm on the patio, they're right to my right. 8 shell casings found. And those are the 9 total. 1 in blue found by the ATF canine. Canine alerted the evening of. That's around 12:30 in the morning. And the next day when it's light out, they found the other 8 shell casings in yellow. And that ejection pattern, as we're going to see in a second here, is consistent with the ejection pattern of DPS forensic scientist Brunel's review of that weapon shooting the exact same rounds. Let me get to the AK-47. Where was this gun? Where was this gun that he keeps by the patio door? It was hanging up on a coat rack on a bedroom door behind a sweatshirt. And the only reason it was found was Sergeant Flores opens the door stops its momentum, but the gun continued and bumped the back of the door. He looks behind the door and sees this weapon. What's not true in this case? What's not? There is no evidence of a mysterious shot. None. The only person in this courtroom who has ever said anything about mysterious shot is the defendant. His wife doesn't even say she heard a shot. And you heard when Ms. Hunley had Ms. Kelly on the stand, you wonder why we asked the question, what were you watching? I was watching a news show. What was the volume? It was on 20 out of a range of 100. You're in your living room. Your husband's in the kitchen. He hears a gunshot and you don't. And you're watching and listening to news at a medium volume. That's a mysterious, magical gunshot in this case. No evidence that it exists. None. The other one is the boogeyman. We've got a lot of armed men on the property. It went from 5 to 10 to 15, all carrying packs, all with rifles, walking this property. And they changed the number, they changed the distance. They're creating a fear here of the boogeyman being there. There's no evidence. None. We have 2 migrants come to the U.S., heading back to Mexico, who get shot at. Defendant under fire. No evidence whatsoever. They did a search with a metal detector from the house to the victim, no other shell casings, and from the victim out, no round or other shell casings. None. No damage to the house. If you're being shot at, if you're in your house and you're being shot at, where's the damage to the house? No evidence of drug packs or drugs. No evidence of robbery or theft. No evidence of struggling or dragging. None. Someone else must have shot the victim because the victim stumbled over. This is a severed aorta. You don't stumble around. You heard Dr. Tim. You may take 1 or 2 steps and may utter a gasping phrase or two, and you're done. During voir dire, I think it was mentioned by counsel that this is a shoddy, I'm paraphrasing, this is a shoddy investigation. Here's everyone involved in this investigation. Local law enforcement, we've got Border Patrol agents, we've got DPS, we've got outside experts, medical examiner, we've got a guy from Washington, Mr. Wyatt, we've got Ms. Telsel from the East Coast, and we have the FBI. This is a thorough investigation. This is Agent Douglas, who you heard on the stand testify about downloads from the defendant's cell phone. You saw that? AK getting a lot of work. 33 dealt with this week. AK hot. AK hot again. It's either fight or run, and I'm too old to run. There's BP cameras out there. Anything like this? Expert witness you saw, I mentioned him earlier, DPS forensic scientist Brudenell, talked about the functionality of that AK-47. It works, it's operable. Talked about the ejection pattern, which is consistent with his testing with the results on the scene. Rounds coming out to the right. Doesn't matter if you're right-handed or left-handed. No matter. The projectiles are coming out up right-hand side of the gun. The injury is consistent with a long-range shot. Why do we know that? Well, we have 2 things we got going on here. We have GSR, we have that cloud from a gun. When you shoot a gun, there's a cloud of particulars that come out. And you heard testimony that usually within 20 feet, some of that cloud dust is going to come on to the person. Well, there is no GSR in this case, which means only other reason is you're further than 20 feet from the victim. That's what it means. This ain't no close-range shot of holding a backpack and doing a gangster-style shot. That's not what's going on here. Because there would be a cloud. There'd be gun residue all over that person, all over him. There's none. You heard the witnesses. They damped the clothes all around and submitted to Ms. Tossell. You heard testimony. No GSR found, which means further than 20 feet. I think it's easy to say that 115 yards is further than 20 feet. You also heard from DNA and fingerprint analysts from DPS. The reason we did is we're doing a thorough investigation here. We're demonstrating to you, you deserve to know that the government is doing a thorough investigation. That's our job. And there is none. Not surprising. There's only 2 people involved in this case. Or 3, counting Daniel. Rick Wyatt, expert from Washington, talk about ballistics, talk about the wound, the bullet used is consistent with the wound, shooting reconstruction, and he talks about the bullet being in yaw. I call it a wobble. It hit something on its way. It hit something on its path. And so instead of being like a nice little spiral, it's like a duck, like someone throwing a duck football. There's a little spiral off. When it hits that body, that's why the entry room's a little off. And you saw the scene. Mesquite trees all around. Could hit a branch anytime. And it was Rick Wyatt who asked SO to go cut that branch. Just to double check. There's no evidence on the branch. But it's an indication to you all why the bullet is in yaw. It hit something before it hit. And that's why there's no bullet wipe. Which means when the bullet's carrying some of that particulates on its way, on its journey, and when it enters the body, it's going to leave what we call a bullet wipe. And there is no bullet wipe in this case. Because that bullet is in yaw, because it hit something before hitting the victim. There's no mystery to that. Ms. Telsell talked about no GSR found. You heard from Dr. Tim, cause and manner of death, homicide, bullet wound. Injury is consistent with an AK-type weapon. From collapse to possible step or two, there is no walking with that injury. There is no walking, stumbling around. There is not. Then I just want to talk about the skeleton because that was demonstrative used in this case, where defense counsel put the rod, the trajectory rod, through the skeleton and said that must have been the trajectory of that round. And it's kind of like a gangster-style shooting where you're trying to take the backpack and you're coming up from underneath and you're shooting. But you heard Dr. Tim talk about this, and you heard Daniel. Possible reason number one, when someone shoots a weapon at you, what's your reaction? To duck. And the moment you duck, you line that body up. You line that body up. And second, you heard Dr. Tim say, once it hits that rib cage, it gets deflected inside the body. There's two reasons why that is the way it is. Not because there's a robbery, not because there's 5 guys out there trying to take quote-unquote drugs off the victim. Entry wound, like I said, in yaw. Exit wound, come out of the body. It's interesting. Had my gun, shot my gun. He says at 2:30 to Border Patrol. Doesn't tell Marcel ever again. He's had a couple conversations with Marcel after that. Does not tell him. Does not tell BP Heredia on scene. Had my gun, shot my gun. Does not say that. Does not say to Deputy Monreal on scene. Does not say had my gun, shot my gun. Does not say it. Castaneda on scene. Does not say had my gun, shot my gun. These are officers who are responding to a code 3. This is lights and sirens. This is an emergency. Does not tell Deputy Lopez, had my gun, shot my gun in this event. Does not tell Sergeant Rodriguez, who's the one who pronounced the victim dead, I had my gun and shot my gun. Does not say anything. Nothing. And you wonder why no one's looking for shell casings around the property? Because no one knows, quote, he shot his gun. No one knows that. Because the only person who's talking to Border Patrol is going to be Detective Ainza, and he's here at the station. The defendant never says, had my gun, shot my gun. Never. And Ainza, after 30 minutes, he finally admits, had my gun, shot my gun. Dispatch Supervisor, Miss Huerta. Defense Exhibit JJJ. At 3:05, Border Patrol contacted Wanda Kelly, and Wanda Kelly, according to dispatch, says, my husband's giving chase. Okay. Husband's giving chase. And to their story, there's 5 armed gunmen with AR-style weapons on my property. There's a shootout, and you're going to take your weapon and go chase them. You heard it on the dispatch log. It's Exhibit JJJ. You guys can pull it up. Canines and the defendant and the canines are on scene first. And he says, there's a quote, canines disturbing the scene. Canines are at the body. 6:42, Rodriguez is trying to confirm with Border Patrol the subject struck something. There's no jumping to conclusions. None whatsoever. He's asking for confirmation and he gets confirmation. Deputy Castaneda, this is Wanda's statement when he's on scene. 5 individuals, some carrying rifles. Defendant grabs his rifle he keeps by the door, not hanging in the bedroom door under a sweatshirt, keeps it by the door. Went outside, heard shots outside. Does not say the shots she heard were the defendant's shots. And then he takes off and leaves her to go chase the marauders. Defendant states that they were running south and pursued. Importantly, Castaneda on scene, no rifles, no backpacks, no signs of a large group of 5 people passing through. None. Agent Marcel, it's important. Agent Marcel told you there's no RIP crews in the past 10 years. No AR-15 rifles ever found in the past 10 years. And if this is being reported, that quote, he said it meant to him, he thought it meant, is this being brushed under the rug? Undocumented migrants, you heard testimony. Migrants, not drug dealers, not gun-carrying, toting drug guys, but undocumented migrants coming here to the United States for a better life make up 98% of all apprehensions. 98%. They all wear camo because migrants also don't want to be detected, and they all carry backpacks with food and water. There's no mystery here. Zero, because you have a backpack. None. Migrants use radios for pickups. When they come into the country, they're going to get picked up in a car to get transported. Yes, this is all arranged. We're not dummies here. We know how this works. But having a radio does not mean you're a drug dealer. Having a radio means you're communicating with someone so you can get picked up later on the side of the road. So you can be traveled to Tucson or Phoenix or wherever you're going. Defendant was reluctant to have the SO respond. And cartels, when they get involved, they make things messy. There's no single shot with a cartel. None. Daniel, the victim, an eyewitness. From Honduras, extreme poverty.
Counsel?
Yes,
We're
ma'am.
about due for, I think the jury's been in here since about 9 o'clock, so it's been about an hour and a half. Well, I'm sorry to interrupt you, but
No problem.
we have to take a recess. So we'll take a 20-minute recess. We'll be back here in about 10 to 11. We'll stand at recess until 10:50, 10 to 11.
Please rise, come forward.
Is present, and let's bring in the jurors, please. Defense counsel, have you seen the proposed draft verdict form from the state?
I did, yes, Judge.
Okay, we don't have to talk about it. I just want to we'll talk about it later. Just want to make sure you had it.
Please rise.
Please be seated, and the record will show the presence of all the jurors, counsel, and the defendant. And as soon as you're ready, Mr. Jetty, you can continue with your closing argument.
Thank you, Your Honor. We left off with speaking about Daniel, the second victim and the eyewitness to what happened. What Daniel is not, he's not part of a drug organization. He's not. He doesn't work for the cartel. He does not. 6th grade education, and he knew Gabrielle for about a year. There's a picture of him in testimony. I'm talking about consistent statements. AK-47 shot, Red Horse, he also nailed it on how the victim died, clutching his chest, arm up. And that is the picture we see of Gabriel. They crossed, no weapons or drugs. No one in the group had weapons or drugs. No one. Returned to Mexico, and the shots were fired. These are two unarmed migrants heading back to Mexico. Shots coming from the defendant's property. He tells you shots were coming from the right-hand side, and the horse is saving his life. Heard 8 to 10 shots. There were 9 shell casings found. Consistency. And he is scared. Being shot at with an AK-47 is serious. Seeing your friend die in front of you is serious. Grabbed his chest and said, "I'm hit." Agent Heredia, first on scene at 2:40. No people, no tracks, looking for the defendant. Remember, this was an active shooter response. Saw no rifles, no backpacks, no drugs. And the defendant was calm. Kelly said, when he met up with him, he said that 5 to 7 people were carrying bundles. He went from 5 people to 10 to 15, back down to 5 to 7. The never mentions with Agent Heredia, never mentions he said he was shot at. Never mentions he was shot at. Never mentions he saw a weapon. Never mentions a weapon was pointed at him. He's calm. Never mentions he even fired that weapon. It's 10 minutes after this shootout event. Unreal. Miss Kelly saw 5 armed men. Kelly went after them, heard 4 shots. Those are the 4 shots, 4 of the 9 shots by the defendant. The defendant said, "This baby is always by the door." And that's the AK-47, which is behind the bedroom door, hanging up on a coat rack behind a sweatshirt. That's the same AK-47 that he always keeps by the door. And he says they were possibly carrying rifles. Officer asked, did the armed men shoot at him? Didn't know what direction they shot. Justification instructions. There's a litany of those in your packet. You got one for use of physical force, one for self-defense, one for use of deadly physical force, defense of a third person, and defense of premises. That's your homework. I'm going to tell you, cheat sheet is always a reasonable person standard. So when you see 2 unarmed migrants walking southbound beyond 2 fence lines, and you take your AK-47, you walk out and don't say a word, point it at them, and you shoot, would that be what a reasonable person would do in that situation? The answer has to be no. The answer has to be no. No evidence of any armed gunmen. No one found on BP footage. No foot traffic. No other shell casings. And they used a metal detector. I think they used up to 3 metal detectors on 2 different days. No other shell casings found. No one heard the mysterious shot, the made-up shot the defendant now claims started this entire event. He has to give you something. The guy give you something to justify why he shoots 9 times at a migrant. He has to give you something. He gives you this, quote, mysterious shot that even his wife does not hear. No evidence of drugs, guns, a struggle, robbery, anything. And when the cartel gets involved, they leave things messy, but they also don't leave evidence. No evidence of any rip crew in the area. And you heard Agent Marcel on the stand. Not in the past 10 years. Not in the past 10 years. No justification for stepping on your patio with an AK-47, not giving a warning, and shooting 9 times at 2 men who are southbound away from your property. No justification at all. Reasonable doubt? You got jury instruction on that? What I want to talk about is your common sense and experience. We're in this is a magical area we're in. This is what democracy is about, sitting in a jury, listening to a case, and determining the guilt and innocence of an individual. This is what our democracy is about. But you still use your common sense you use in everyday life. You still use it. I'm going to give you an analogy. I think the judge used the analogy for direct and circumstantial evidence with the rain outside. He told you if you didn't see it, you have no direct evidence of it, but you go outside, there's circumstantial evidence of rain. I want to use the same thing for reasonable doubt. We're sitting inside this courtroom, and you go outside, the facade's all wet, the pavement's all wet, people are carrying umbrellas. You were here all day long for the past 4 weeks, but you're here all day long. You don't hear it rain, you don't see it rain, you don't smell it rain, you don't smell anything. You don't smell the bushes and the wonderful odor. You don't smell any of that. However, is it beyond a reasonable doubt it rained? Yes. Is it possible that a truck came by, a fire truck came by and sprayed the facade and the ground? Yeah, it's possible. But that's a ridiculous doubt. Use that same standard here. That same standard. There is no bandits out there threatening the defendant. None. Facts again, Gabriel and Daniel were shot at. Gabriel is dead. Killed by a high-powered weapon, an AK-47. Entry wound, right side, exit wound, chest, lines up perfectly with the defendant's property. We're calling the wheat from the chaff here. Defendant's words, inconsistent. Defendant's words actually were consistent with some of the physical evidence. Shot 9 times. Eventually he says he shot 9 times. And now we have shell casings. Consistent there. And Daniel's words, always consistent with the physical evidence. Steps out, no verbal warning. Defendant shot his AK-47 9 times. Shell casings found. Ejection pattern consistent with what Brunel did on a test of that same weapon with the same rounds. Position and orientation of the body lines up with the defendant's home. I'm going to ask you, I'm going to come back second time, I'm going to find him guilty of second-degree murder. But you also can decide if you're not satisfied with second-degree murder, you can consider manslaughter. And if not satisfied with either second-degree murder or manslaughter, you can consider negligent homicide. And find him guilty for aggravated assault with a deadly weapon against Daniel. I'm going to leave you with this. Detective Ianza says in the interview, the moral of the story is you shot and someone is dead. And his answer is yes. That's all I have here.
Thank you. Closing argument from the defense.
Good morning. I'm the quiet one. Can you hear me? Okay. If I speak too quietly, just wave at me and I will do something about that, all right? So I just want to start off by telling you this about this case. And it's first in your jury instructions when you go back to review them. They're going to tell you don't guess. You're not supposed to make guesses about what happened in this case, and you're not even supposed to solve the mystery or discover all of the facts that were left out of this case. Don't guess. We have this very high standard in criminal cases. The standard here is proof beyond a reasonable doubt. Not is this questionable, not is this suspicious, not even is this likely, not even is this really darned likely. The standard is proof beyond a reasonable doubt. And I'm going to come back to that standard, but we have that standard for a reason. This is the most serious type of courtroom that we ever get in any kind of case in this country, is a criminal case. And for the most serious type of courtroom, we have the most serious standard of proof. And it's your job as jurors to hold the government to that standard of proof. We don't guess when we're dealing with criminal law. We don't guess when we're dealing with criminal charges. So please don't guess. I'm going to ask you to assess the facts of this case. We have two competing versions of events in this case. We have the state's idea, and the state says that Mr. Kelly walks out of his house one day with no provocation whatsoever. He takes aim at a great distance at people who are unarmed on his property, and he fires shots intending to hit those people. That's their version of events. Mr. Kelly and his wife tell something very, very different. And I'm going to talk about what they say happened here, but I want you to ask yourselves while I'm going through that, is what Mr. Kelly and his wife says consistent with the facts, the known facts of this case, the known evidence that has been presented to you? Not, is this consistent with somebody's subjective interpretation of somebody else's words? Those aren't facts. Those are guesses. I want to ask you if what Mr. Kelly said happened is consistent with the facts. And it is. The evidence has showed that Mr. Kelly comes from Montana with his wife, and they eventually settle here, and they begin ranching. The evidence showed you in this case that they had a long time on this ranch before anything happened. They've been here for decades. They are locals at this point. We heard from Wanda about the increased activity that took place on their property that we talked about in the opening statement. Wanda testified to that. You heard from Mr. Kelly about different instances where he was shot at. When he was interviewed by Detective Ainsa, he described those instances. We heard from Gary Wisdom, one of Mr. Kelly's neighbors who's in that same area, the same thing. When he originally started ranching there, he saw small family groups and didn't feel any danger. Gary Wisdom later says, eventually I started seeing bigger groups of men carrying weapons. And he called Border Patrol to report that at times. Border Patrol came out. He has no idea if they ever caught them or not. We heard from Border Patrol that this is a high-trafficked area. There's a lot that comes through here. It's just north of that area where the wall ends. There are people who come through. There are drugs. There are vehicles. We heard from Border Patrol that it's impossible to distinguish nowadays really who's carrying drugs and who are just groups of migrants, because the drugs have gotten smaller as time has gone on. We have heard from Border Patrol that there are things that exist called rip crews. There are bandits. There are people who will rob migrant groups, who will kidnap migrants, who will steal drugs, and who will get into violent altercations with other people who are engaged in criminal activity in this area. That's not Mr. Kelly's imagination. That's what you heard from Border Patrol, who are out there every day on the ground dealing with what goes on out there. Border Patrol also talked about how there are a lot of unknowns. We know the cameras are not that effective. We know people know where to avoid detection. They know how to avoid detection. They know where our cameras are. So there's a lot that goes on that goes unseen and unknown by Border Patrol. They see signs of it, they know it's out there, but they're not able to respond, and they're not able to make apprehensions all the time. And this is what's going on in Mr. Kelly's life during the lead up to this incident on January 30th. The state talks about text messages that Mr. Kelly sends between himself and his friend, Gary Miller, a very close friend who he's known for a very long time. This is somebody who Mr. Kelly trusts and who understands where Mr. Kelly's coming from. Those messages come in that context. Those messages also come in the context of Mr. Kelly receiving continuously information from Jeremy Morcell, the Border Patrol Ranch Liaison. Jeremy Morcell is continuously communicating with Mr. Kelly about large groups on his property. They're nearby. Be careful. We're working a group of this size. It's in your area. It might come your way. They might be carrying narcotics. Narcotics trafficking has picked up around Keno Springs. This is the communication that Mr. Kelly is receiving on a regular basis from Border Patrol. Border Patrol knows what they're talking about. Mr. Kelly relies on that information. The level of fear and concern that Mr. Kelly experiences on his own property is increasing as a result. He chooses to arm himself in case he ever has to defend himself. And he expresses that to his friend, Gary Miller. He talks about the fear. He talks about what's happening on his property. He does it in an over-exaggerated way to help him blow off some steam, to help him feel a little bit better, and to help assuage some of the concerns that he has, because he never knows when something is going to happen. And ultimately, something does happen on January 30th of 2023. Mr. Kelly is in his kitchen eating lunch. It's a day like any other. He's been out about on his ranch. He's planning to do some more chores for the rest of the day. He has no idea that he's about to be in a life or death situation. He doesn't ask for it. He's minding his own business in his own house. When suddenly he sees something. He sees people carrying rifles, carrying backpacks out the kitchen window. He does the right thing. He calls law enforcement. He is not some sort of vigilante who decides he's going to take matters completely into his own hands. He calls for help. He calls the guy who has the badge and the gun. He calls Jeremy Morcell. And he tells him, I hear a shot or there's shooting. I might have to return fire. Immediately, he tells law enforcement that he may have to fire. When he's walking outside, he has heard a shot. This is not a mystery shot, as the state describes. This is a real shot. Mr. Kelly hears it, and the whole situation completely changes in that moment. A gunshot outside of your home is not something you hear every day, and it's not something you hear in the same context with people running with rifles and backpacks across your property. This is a frightening, scary situation. And in frightening, scary situations, people flee, people freeze, or people act. And Mr. Kelly acted. He is being confronted on his own property, in his own house, with criminal activity involving guns in his yard. And he doesn't know what's going to happen next. He knows he needs help, so he calls Border Patrol. But he doesn't know how long it's going to take them to get there. And he doesn't know what these people are going to do in the meantime. The state would have you believe that you have to stay in your house in a situation like that. You do not. The law does not require that you stay inside of your house. In fact, that is not the smart thing to do. Mr. Kelly, when he walks outside with his rifle, his intention is to stop this threat. His intention is to make these people go away. Because if you stay inside your house, you don't know what they are going to do. They're going this direction right now, but after you lose sight of them, who knows where they're going to go? Who knows what they're going to do? This isn't a conscious thought process that Mr. Kelly went through at this time either. This was a split-second decision. He sees a threat, he responds to the threat. Mr. Kelly is the man of his house. His wife is there. He needs to protect himself, and he needs to protect his wife, just like every man should do. And he is 100% justified in walking outside to meet this threat. When he walks outside, he sees people. He sees that they are carrying rifles. He walks out onto his porch. The metal door bangs behind him. It makes a noise. The person in front looks at him and points his rifle at him. And Mr. Kelly tells this to Detective Einsa. He points his rifle at me. Under those circumstances, Mr. Kelly is 100% justified in firing his weapon at that person. He doesn't need to fire warning shots. He is justified in firing at that person in that moment. Again, split-second decision. Mr. Kelly doesn't think, now I'm going to fire some warning shots in the hopes that I will have to avoid doing something else. There is no thought process. This is an immediate life or death scenario. It's an immediate decision that Mr. Kelly makes, and he chooses to not take that shot. He chooses not to fire at that person. Instead, he raises his rifle up above the tree in front of him. And you all have seen the tree. You've been to the patio. You know what this looks like. He raises it up. He fires warning shots. As the state said, he could have emptied this magazine. He doesn't. He stops shooting because these people start to run away. He has some more conversations with Agent Morcell about this. These folks are going somewhere. They're gone. The threat is over. He goes out to check on his barn, and he encounters Border Patrol. He has already told Agent Morcell that he was going to fire shots. As far as Mr. Kelly knows, Agent Morcell has passed on that information to everybody else who's responding. He is not required to tell every single law enforcement member every single thing that happened to him that day. He assumes that they already know because he already reported it, and that is why they're there. During this encounter, sheriff's deputies have some communication with Mr. Kelly. They have some communication with Alan, Mr. Kelly, and they start to search this area east of the house. You've heard testimony from these deputies. They're searching this area east of the house. Border Patrol is traveling south. Everybody says, we're looking for Mr. Kelly. And Wanda said that he went south. And yet, the sheriff's department are searching east of the house. Why are they searching east of the house? They say they're just looking for Mr. Kelly. It's because Wanda told them this is where we saw those people. And so they're searching east of the house to try to find evidence of the folks who Mr. and Mrs. Kelly described. They comb through that area. They go over the two fences. They spread out. They're looking for people. They're looking for weapons. They're looking for people who might be injured or who might be hiding. And they don't find anybody. They don't find anybody. Ultimately, they come back and they talk to Mr. Kelly and his wife. And Mr. Kelly and his wife say, this is the area where we saw people. Mr. Kelly tells them, I heard a shot. He hears a shot and he sees people running with backpacks and rifles, and law enforcement chooses not to go and look again. They don't think it's important. They don't think it's worth it to try to go see if they can find something else now that they have more information. They don't sit down with Mrs. Kelly. They don't tell her, slow down a minute, let's walk through this one step at a time. Tell me what you saw, tell me what you did, tell me where you were. They don't do that with Mr. Kelly either. They don't bother to slow down and get the information. They describe Wanda as being upset. Castañeda, Deputy Castañeda, who talked to Wanda, said she seemed upset, she seemed confused. She was distraught by what was happening. And yet, nobody took the time to ask her to take a breath, to slow down. Let's talk through this. Same thing with Mr. Kelly. He's just had this encounter. Imagine you're sitting in your kitchen and you hear a shot and you see what's happening and all this happens. Your adrenaline goes up. Your whole body is on alert when something like this happens. And when law enforcement gets there, it's still sort of coming down. It's still kind of washing out of you. Under those circumstances, people can't be expected. People who are victims of crimes, like Mr. and Mrs. Kelly were that day, they can't be expected to fully and clearly, from beginning to end, articulate to law enforcement exactly what happened. Law enforcement is trained to deal with that. Law enforcement should recognize that and talk to someone. Talk me through it slowly. That's all they had to do. Nobody did that. And now the fact that Mr. Kelly made some omissions because he's in that state of fear and agitation and adrenaline and excitement, that's being held against him. And that shouldn't be held against him. That should be held against the officers who didn't properly recognize the situation, who didn't ask questions of witnesses. You heard the state argue this was an emergency call, lights and sirens, active shooter. Law enforcement was on high alert when they came to the scene. They had their rifles out. And yet they fail to recognize that Mr. and Mrs. Kelly might be in a state of emotional agitation, to put it mildly. They don't recognize that. They don't do a slow walkthrough of the information. They don't take their time. They don't even go do another search. And now we are left with questions. We do not know if Gabriel Quinn Butimea's body was there when law enforcement arrived. That's a question that's outstanding. We don't know the answer to it, and now we never will. Ultimately, law enforcement leaves, and later in the evening, Alan finds this body on his property. This is the second time this day that things have gone from normal and regular to high anxiety, high stress, extreme situation happening here. I've never discovered a dead body on my property. You folks probably haven't either. But who's to say how any of us is going to react when we come upon something like that? How are we supposed to feel? What are we supposed to think? What is an appropriate response to finding a dead person on your property? And imagine what must be going through this man's head. He knows what happened earlier. He knows what he saw. He knows what he did. He knows he fired shots up over the tree in front of his patio, and now he's stumbling upon a person. And he doesn't know what happened. But he's a smart man, and he can put two and two together. And any intelligent person who's in his situation, imagine being in a situation where you fired shots and you know you didn't shoot this person, but you know you fired shots. That is scary. Anybody in Alan's shoes is going to be thinking, oh my Lord, What are they going to think when I call this in? It's a terrifying scenario for Alan. What would a guilty person do? What would someone do who's come across this body and who thinks, I probably shot this guy? What would a guilty person do in Alan's shoes? Someone with a huge, expansive property, someone who knows law enforcement was already here and they left, someone who knows that's where I was standing when I fired these shots. A guilty person had every opportunity to cover this up, and he would have been able to do so effectively. He could have disposed of the weapon. He could have picked up the shell casings. He even could have disposed of the body on this property. He didn't even need to do that. He could have just picked up the weapon, hid it, buried it somewhere, buried the shell casings somewhere, and never made a phone call and just left on a trip for a while. That's all he had to do. That's all a guilty person had to do. That's not what Alan did. Alan, even though he's standing there and even though he knows this looks bad, I don't know what's going to happen, he does the right thing. And he does the right thing because it's the right thing. You can tell when he's having these phone calls. In the state, they pull up some excerpts and they read them in their tone of voice. I encourage you to review these phone calls and listen to Alan's tone of voice. Listen to his demeanor. Hear what he's saying. Is this a person who knows that he's guilty and is trying to cover things up, but nevertheless is calling law enforcement, which is what the state wants you to think? Or is this a person who is completely scared and shell-shocked because he knows he didn't do this, but he knows that calling it in is the right thing to do? And he trusts that law enforcement is going to do the right thing. He trusts that they are going to listen to him. And so he calls it in. He calls the Border Patrol, the guy with the badge and the gun, the guy who he called earlier, the same guy who sent all the deputies out earlier and who sent Border Patrol out earlier. There's no possibility that Alan thinks the Border Patrol is going to sweep this under the rug. No possibility whatsoever that he thinks that. He's still in a distraught state. He still doesn't know how he feels. He's still communicating in a vague way to Agent Morcell because he is in shock. What's the appropriate response when you find a dead body on your property? Can anyone say, here's how you're supposed to act, and if you act differently, then that's wrong? People act in all sorts of ways when confronted with shocking and frightening scenarios. And Alan couldn't form the words. He called for help and he tried. He tried to communicate what he was finding, and he did. You cannot listen to these phone calls with, well, there aren't phone calls recorded with Border Patrol, unfortunately. You can't listen to the phone call that Alan has with the Sheriff's Department and conclude that he's not communicating that there is a dead body on his property. He makes it very clear with the words that he can call to mind in that moment, which is a terrible moment for Mr. Kelly. There's a lot made about the phrase animal, or the use of the word animal. Agent Morcell testified that he used that word first. He asked Mr. Kelly, what is it, Mr. Kelly? You're not telling me what's going on. Is there an animal? And Mr. Kelly responded to him and said, well, as opposed to a vegetable or a mineral, if you know what I mean, he's clear. He's making himself clear. And then he does the same thing when he's on the phone call with the Sheriff's Department. Something that else goes to Mr. Kelly's mind when he's talking with the Sheriff's Department is the Sheriff's Department dispatcher tells him, you said you shot something. The dispatcher tells that to Mr. Kelly when he has never said anything like that. Again, imagine, how must somebody feel knowing I fired shots earlier. I know I didn't hit this person. Here's a dead body. Oh, I'm afraid to call this in, but I have to call it in. And then when dispatch talks to him, dispatch says, you said you shot something. That is terrifying. That is a terrifying mistake that dispatch made, and it's terrifying for Alan to hear that. That's all in his mind when law enforcement is responding to his property. That's also all in the minds of all of the law enforcement personnel who are going to this property. They are being told incorrectly that Alan stated he struck something or he shot something when Alan never made that statement. And it's nobody's fault. Alan's on the phone with Agent Morcell. Agent Morcell is on the phone with Agent Tercy. Agent Tercy is relaying that to Agent Layugan. Agent Layugan is relaying that out to the Sheriff's Department. So you have all of these layers of telephone. And of course, things get lost in translation. It's not necessarily anybody's fault, but it is a crucial, crucial defining factor in this case. The investigators go out there already believing that this guy has confessed. They already have their suspect before they arrive at the scene. When they're at the scene, Lopez, the first person who comes out, he talks to Alan. He finally records a conversation. And his recording shows that his report was wrong. This is a theme that comes up repeatedly in this case. Law enforcement documents statements, especially Alan's statements, especially Wanda's statements, incorrectly. We have two reports from the first call from two different officers who both at the same time talked to Mrs. Kelly, and they both say that she said two completely different things. None of these conversations are recorded. Documentation is unreliable. The conversations between Mr. Kelly and Agent Morcell, not recorded, unreliable documentation. Finally, when we have a recording, it's Lopez, first person on the scene. He records him. And Lopez documents that conversation incorrectly in his report as well. According to Lopez's report, he says to Mr. Kelly, "Do you know if you shot him?" And Mr. Kelly says, "I have no idea." That sounds pretty bad. Sounds like Mr. Kelly's admitting he might have shot this person. That is not what Mr. Kelly said. When you listen to Lopez's recording, the recording says, "Do you know who shot him?" And Mr. Kelly says, "I have no idea." Very, very different. The documentation of the statements made in this case is really concerning to anybody who's worried about law enforcement being objective. You have Omar Rodriguez, who gets out and stands near the body. He's looking at the body. He's got this in his mind, and he speculates about the angle of the shot, the same way that you heard the state speculate in their argument to you about the angle of the shot. He says this shot comes in here, goes out here. There's the house over there. Aha! The shot must have come from there. That's not what any of the experts say. The experts say you have no idea, based on this evidence, where this shot came from. And we're going to get to them in a minute. But the initial investigators feel very free to speculate. You have Sergeant Flores, who takes photographs of the body. There's no note that the backpack is unzipped. Nobody raises that as an issue in any reports. Nobody raises the issue about how the backpack's pulled up over this person's head. Nobody raises the issue about how the fanny pack buckle is broken and the fanny pack is lying next to this person. There are photographs, we can see those things, but nobody seemed concerned about that. Nobody seemed to think maybe there are other crimes that have taken place here besides the obvious crime of this person's been shot. Nobody ever considered that there was any other evidence of any other crimes. Sergeant Flores on the stand specifically said, "No, I didn't see any evidence of any crime. None." Amazing. It's amazing. thinks more about the emotional aspect of this. These are human beings. Alan's a human being, Wanda's a human being. We're not robots. We all react differently in different situations. Alan's on scene. Nobody's talked to him. Still, nobody's asked him, walk me through what happened. Show me where you were. Nobody does that. And then they put handcuffs on him. And they put him into a police car. Imagine what he must be thinking in that moment. Imagine just that feeling of, oh my gosh, this is really real now. They're taking me away in handcuffs from my house. I don't know if I'm coming back. That's an unbelievable moment for anybody to have to go through. Imagine Wanda. She's been sitting in the back of a police car. They don't ask her what happened. They don't walk her through the scene. They don't ask her anything. They put her in the back of a police car. Wanda, a person who has obviously never done anything wrong, who's obviously the victim of a crime. They put her in a police car. They take her to the station. That's an arrest. They arrest Wanda. They don't have any reason to do that. And right before they drive away with her, she sees her husband walking past the car in handcuffs. How does she feel when she's being taken to this interview? How does Alan feel when he's being taken to this interview? Would it be reasonable to be scared? Of course it would be. Would it be reasonable to be really concerned now? Maybe I don't really trust these investigators. I'm in handcuffs when I called them. That's a big concern. This is what's going on emotionally when Alan and Wanda are interviewed by law enforcement. And again, there's no slow walkthrough. There's no show me on a map where this is. What did you do? Describe this to me. Wait, let me back you up a little bit. Tell me more about this. They don't do any of that. There's browbeating. There's tactics used to try to scare this man into confessing. Detective Einsa tells him, you shot this person. That's pretty scary, especially if you know you didn't shoot this person. There's, we're going to find that rifle and we're going to do ballistics. By the way, what's Alan's response to that? He says, you don't need a search warrant. I will show you where the rifle is. I will show you where the rifle is. This rifle that's supposedly not in its proper place, according to these guys. Alan says, I will show you where this rifle is. Detective Einsa says, no. Fair enough, okay? Then we get to significant issues of words being changed, and this starts with Alan. He's in this interview with Detective Einsa, and watch it. Don't pick out a line here or there. Watch it. You have the whole interview. Look at the whole thing beginning to end. Listen to the context. Listen to the tone of voice, the body language. It's a whole. Don't pick out a line and decide what it says. Watch it. Repeatedly, Detective Einsa says, you shot this person. You shot at these people. Alan says, no, I never did that. The state talked about a part in that interview where he was asked, did you shoot? And he doesn't answer. Watch the interview. Detective Barba asks him, did you shoot? Alan pauses, and then Detective Einsa jumps in with a different question, and Alan answers that question. He never denies having shot his rifle, ever. He's asked, he says, yes, I shot this rifle. I shot it up. I shot it over. Detective Einsa says, at, over, same thing. Alan says, no, it's not the same thing. It's a different thing. And there's back and forth about that a lot. Alan obviously thinks at and over are two different things. Alan also repeatedly says, I never chased anybody. I never went after anybody. I don't know where you're getting that. Watch the interview. It's there. In spite of this, law enforcement essentially fabricates a confession. They write down on the booking form. That booking form is their statement of probable cause. Here's what happened. Subject, he was chasing people. He shot. He admitted he shot at multiple subjects. That was not true. Alan never said that. Law enforcement wasn't listening, and they didn't care. They already decided that he was guilty, and they were perfectly fine inventing words for him, words that were the opposite of what he said and putting those down as if he said them. There's a lot made about Wanda. The treatment of Wanda in this case was just disgraceful. They're trying to say that she's lying to protect her husband. She said 5 and then she said 2. They come up with these extremely nitpicked, not recorded, supposed inconsistent statements to say that she's lying. And I would just submit to you that if Wanda were lying about what happened in this case, all she would have to do would be to say, I saw these guys, he pointed a rifle at my husband. That's all she would have to say. She didn't say that because she didn't see. But if she wanted to lie about something to protect Alan, very easy for her to do. That's all she would have to say, and nobody could contradict her. She didn't do it. So confirmation bias is a big thing that runs through this case, and it's the tendency to interpret new information and new evidence to confirm pre-existing beliefs and conclusions, and that plays a very big role in this case too. They do this interview with Alan, they don't listen to the words he says, they make up new words, and they arrest him. They don't wait until they can do ballistics. They don't wait until maybe they can find some witnesses. They don't wait until they can do forensic testing or any drone footage or anything. They don't wait. They just go straight for this guy. And every single thing that they do after that, they design to confirm the decision that they've already made. It's natural. Human beings, we like to confirm that we're right. It's really uncomfortable to say I might have made a mistake. Maybe I was wrong. And so when they get a phone call from somebody calling himself Miguel, who says he's related to the family, they don't question it. And then when it turns out that that's false, well, oh well. They're not concerned that people are coming forward making false statements about this case, even though apparently they've talked about it, I don't know. But it doesn't bother them. Then there's this person, Ramon. And he says something different. He comes forward under different circumstances too. Does anybody bother to analyze his statements? Does anybody bother to compare his statements against Miguel's statements or Mr. Kelly's statements? Does anybody bother to compare Ramon's statements to the physical evidence in this case? No, of course not. They don't need to. They have their guy. They have their conclusion. Then we get to Daniel. The state says he makes consistent statements. And remember, if you're inconsistent, that means you might be lying about something. Well, Daniel doesn't even tell investigators what his name is in this case. He comes forward under very suspicious circumstances. He comes forward after this has all been out, after they know that Mr. Kelly's been arrested. His picture's been all over the place. Their version of events is out there for anyone to read, for anybody to think about, for anybody to make something up about. And here comes Daniel. And he lies about his name because he doesn't want to get deported back to Honduras. And he lies about his criminal history. He's asked, have you ever smuggled drugs in the United States? He says no. That is not true. He's telling a lie. The state says he's not associated with any criminal organization. He's not a drug smuggler. Daniel says, I'm not a drug smuggler. Well, except for when he is, because he took a plea in federal court under oath to smuggling drugs. Lied about his name to federal court also, by the way. You hear from law enforcement that you can't just accept a statement as the truth just because it's a statement. You have to test its credibility. You have to see if it matches up with other statements, with physical evidence, with known facts of the case, with forensic evidence. And that's how you can assess the reliability of a witness statement. I'm not going to get the whiteboard out again. You guys have seen me do it already, but you've got a body found 115 yards east of Mr. Kelly's house. You've got that body lying face down. You've got Daniel stating, we were 10 meters away from the house. We were to the west of the house. We were facing the border wall. Border wall is 2 football fields away. The shots were coming from over there, away from the house. That is impossible to believe. It could not have happened that way. We know for a fact, we're not guessing, we know for a fact that it did not happen the way that Daniel said that it happened. We know for a fact that Daniel previously told investigators he was 15 meters away from the border wall when this happened. We know that for a fact. State says he's consistent. How is that consistent? It's not. We know for a fact that Daniel claims he gets right up to that road that goes by the border wall where the pines are. I look back, I saw the person. We know that for a fact. We know that that is impossible. You all have been out there. You know what the end of the wall looks like. You know what this road looks like. That is impossible. We are not guessing about that. That is a fact. We know that the body's not on the west side of the house. Fact. We know that the body is not 10 yards away from the house. Fact. We know that there is no Border Patrol road that goes through this property that goes directly to the end of the wall, like Daniel said it did. Fact. We know he is wrong. What does that mean? It means he wasn't there. It means he is telling a story. Why? We don't know. But you can't be there and get it this wrong. It is not possible. I don't care if you have a 6th grade education. My kid has a 3rd grade education, and she can describe a place. It's not that hard. Nobody questions this either. Forget what Daniel says for a minute and how obviously false and concerning that is. What is wrong with the investigators in this case? Raul Rodriguez interviews Daniel, and he says things that Raul Rodriguez, Detective Rodriguez, admits these are not making sense. Instead of pursuing that, for example, he says this took place west of Nogales. No, it didn't. We know that for a fact. It took place east of Nogales. Instead of pursuing that as a possible problem, as a possible, maybe this person's not so credible, maybe they have another motive for coming forward, law enforcement doesn't bother asking any questions. Instead, they provide explanations. They provide help. They provide suggestion. They say, well, are you sure you were that close? That sounds pretty close. Are you sure? Well, maybe you don't know because you were running and maybe you were scared and so you didn't really know where you were, right? They make suggestive statements to this witness in an interview when really they should be suspicious about this and they should do some detective work to find out what the truth is, not to bolster what they've already decided they want the truth to be. That's not how an investigation should work. And let's remember, Daniel first comes forward because the sheriff goes into Mexico to meet with him. We don't have any good explanation for why the sheriff did that. There was a meeting that was arranged at the port that happened shortly after that. It's possible to do it that way. It's possible to do things the legal way. Why is the sheriff going into Mexico? Why? He doesn't wear a uniform because if you wear your uniform in Mexico, they get picky about that. That's what he said. It's quite the euphemism. and then they don't record this interview, and then they record part of it, and they've got no good reason for why they did that. That is sketchy, and that sets the tone for this whole investigation. So that's some of the facts, that's some of the evidence that you've heard from this witness. Let's talk about the forensics. The medical examiner's report essentially says there's no way to determine the time of death. This is a very significant fact in this case. What was the time of death? Because if his body wasn't there when the sheriff's department searched this area, then Alan has nothing to do with this. We have evidence that Omar Rodriguez examined the body. He says the torso is still warm. This is significant information. He could have passed that on to a medical examiner to get some sort of scientific determination of time of death. Didn't do that. They put the body in a cooler. They destroy any possibility of accurately determining a time of death scientifically. And the medical examiner's report proves that a gunshot wound is the cause of death. It doesn't prove which gun, doesn't prove which type of gun, doesn't prove which type of ammunition, doesn't prove even long gun or handgun, doesn't prove anything other than gunshot wound. Okay, great. The ballistics. Let's talk about that. See what can be proved in this case, what they did prove forensically. They talk about this as a long-range shot. I recall the ballistics experts testifying that what that means is this shot was fired from a distance of 6 feet away or further. That's a long-range shot. So they've proven that this shot was taken from 6 feet away or further. Anything in between is a guess, and we are not supposed to guess. The ballistics, obviously there's no bullet, so they can't prove which weapon this came from. They can't prove which type of weapon this came from. They can't prove, again, which type of ammunition this came from. The shell casings, we heard testimony about shell casings that are found on the patio. They can't prove which direction the shooter was pointing. You make a circle around the shell casings. Shooter could be standing anywhere in that circle. They can't prove if the shooter was pointing straight or up or something else. Interestingly, the ballistics experts testified that had they known, had they been told that there was a possibility that this rifle was shot in an upward direction, they could have done testing on the shell casing pattern. And they might have been able to come to a conclusion about that. Yes, it was pointing up, or no, or it's inconclusive. But they didn't do the test because they were never asked to by the state. The investigators in this case never tested their own theory. They never considered that what Alan said might actually be supported by some evidence, and maybe we should look for that evidence too, not just evidence that shows that he's guilty. They didn't do that. And now we'll never know. Imagine if this were a sexual assault case and there was DNA of the perpetrator involved, and the investigators said, well, we could test that DNA, but it'll probably be inconclusive, so we're not going to test it. That's outrageous. That is outrageous. We have a right to expect that people who are investigating people for serious crimes are going to examine and test every piece of evidence that they can, even if it might not tell them something. What if it could? What if they did that test? What if it showed that an expert could say this rifle was pointed in an upward direction? It could do that. We would want to know that, wouldn't we? Before we decide what happened in this case. They didn't do it. The ballistics also, you've got this field of obstacles in between the porch and where this body is eventually located. You've seen the photographs, you've been to the scene, you know how many things are in between there. What I didn't hear the state address is the problem of the point of aim and the point of impact for this rifle. I'm not going to rehash all of that, but ballistics experts said that if that entry wound, and this is assuming the person's just standing there, we have no idea where this person was when he was shot. The ballistics experts testified that they could not possibly determine that based on the evidence that they saw. But the point of impact on this person was about 4 feet off the ground, which according to the experts means Allen would have to been aiming, if he took the shot, at a spot that's about 3 feet off the ground, which means he's aiming down. And you saw everything that was in the way. You saw the smoker, the pergola, the patio, the table and the chairs that's on there that's made out of cement. If he were firing in that manner, there would be evidence. The fact that there's no evidence of any bullet impacting anything in that entire field is evidence that supports what Allen said happened. If he fired where he said he fired, of course you don't expect to see bullet evidence in that field of obstacles, and you don't. The physical ballistics evidence is consistent with what Mr. Kelly said happened in this case.
Ms. Larkin?
Yes.
It's about 5 to noon. I think it's appropriate. It looks like you moving into a new area, so it's a good time to break. We'll take our noon recess. Same routine as we've been following all week long. We'll take a noon recess. You can go out to lunch. Please be back in the jury room at 1:30, at which time the defense will continue with its closing argument. We're in recess until 1:30 in the afternoon. Thank you.
Please rise, por favor.
Thank you, everyone. Before we bring the jury in, we're back on the record. Has the defense had a chance to, yeah, folks, you can be seated. Thank you. I want to be ready with the verdict form. Did you get a chance to look at that? We can talk about it more formally, but any input?
I took a look at it. I didn't have any issues with it, Your Honor.
All right. Well, you can take another look at it. I just wanted to
Okay.
see if there were any major issues, and there are none, so.
We do still need to make the record on the dangerous nature aggravator.
Oh, did you folks talk about that?
They're the ones who asked for it, Judge. I just want to make sure we have a record that they've asked to address the aggravation, the dangerous nature aggravator in the aggravation phase and not in the trial phase.
Well,
Right.
So generally, we would have an interrogatory for the dangerous nature of the offense. We don't have that interrogatory because they've requested that. I just want to make sure they waive any issues with hearing that in the aggravation phase instead
right.
of the trial phase.
well, if you have something, if the defense has something they want to request to be inserted into the jury verdict form, then send me something.
She's referring to the enhancement. They're alleging dangerous nature for the aggravated assault offense, and we had just requested that anything referencing any dangerous nature offense be kept out unless and until there is a conviction, and if there's a conviction, then it's appropriate
okay.
for the jury to
All right, so
consider.
it'll be
That's all.
All right, so it'll be an aggravation phase thing, if.
Right.
Understood.
And Judge, just to be clear, we also asked for the dangerous nature on the lesser included offenses of second-degree murder. We filed an allegation of the dangerous nature of the lesser included offenses of second-degree murder.
When was that filed?
I can give you the date. I just pulled it up a minute ago. It is filed with the court.
But that would be an aggravation phase?
Correct.
If and when, okay.
Yes, yeah.
Okay.
So we can deal with it then if you
All right,
like.
thanks. All right, let's bring in the jury, please.
Rise.
Please be seated. The record will show the presence of all jurors, counsel, and the defendant. And Ms. Larkin, you can continue with the defense closing argument.
Thank you. I just have a few more points to make before I let you go, so I'm going to try not to take up more of your time. I know you guys have been very attentive, and we appreciate that. I just wanted to talk first about some of the characteristics that we observed on the victim, Gabriel, in this case. You saw the radio, you saw the binoculars, you saw the camouflage, you saw the photograph of Gabriel on a different occasion about 9 days prior to these events, wearing the same clothing, also carrying that radio, carrying binoculars, carrying a fanny pack. Could be the same fanny pack, could be different. But all of those things come together, and you heard testimony from Border Patrol who described what they perceive when they're observing somebody who's present in the United States illegally, carrying these sorts of accoutrements. And long story short, this is simply not somebody who's looking for the American dream. There's no evidence that this person is here for those kinds of benign purposes. All of the evidence, in fact, points in the other direction. And we bring that up not, to be judgmental about Gabriel or to not have compassion for him, but when people are involved in criminal lifestyle, it's dangerous. It's more inherently dangerous than simply being a migrant who's coming here. So it's relevant for that reason. I want to talk about what the state is actually asking you to believe, because they haven't really put everything together for you to tell you what happened in this case. And if we assume for a second that what the state is claiming here happened, then we have to try to fit that story into the known facts of this case. And that's always something we have to do. Consider the known facts of the case in next to whatever's being presented to you to see if they make sense together. According to the state, Mr. Kelly is standing in his kitchen and he sees somehow out through those windows all the way out 115 yards to where Gabriel's body is eventually located. And he can somehow see that from inside his house. You all were there. I'll let you all be the judge of whether it's even possible to see somebody from inside the house. But let's say that he does. And let's say that he sees two unarmed people who are just moving somehow out there. The state wants you to believe that he calls law enforcement and makes up a story about hearing a shot and getting shot at, and he makes up a story about seeing people with backpacks. Then the state wants you to believe that after he makes that call to law enforcement, he picks up his rifle, he goes outside, he takes aim at these people who are posing absolutely no threat to him whatsoever, and he shoots because he just wants to kill somebody on his property. That's what the state wants you to believe happened. And then after that, if the state wants you to believe what Daniel says, they want you to believe that Mr. Kelly somehow crossed over those two fence lines and stood over Gabriel's body while Daniel was running away. They want you to believe that that's what happened. Just ask yourself, does that make sense? That's just the first part of this. Does that make any sense when you put it next to the physical evidence in this case and the known facts of this case? They want you to believe that after Mr. Kelly deliberately shoots this person and sees this person on the ground, that he then somehow manages to go over to the area where his barn is after calling and speaking with law enforcement again and telling them he saw people with guns. And then they want you to believe that he brings law enforcement onto his property, law enforcement searches his whole property, Law enforcement doesn't find the body in this case, and then law enforcement leaves. If what the state is claiming happened actually happened, that would be the end of it. But that's not the end of it. The state wants you to believe that even after Allen knew he shot this person, did so deliberately, had no threat, no justification whatsoever to do it, called the cops, they left, he calls again because he thinks, you know, I really should just show them where this body is. They want you to believe that he decided a couple hours later to just bring law enforcement back onto his property and take them to the body. And they want you to believe that he did this without in any way trying to cover up any of his involvement in this, without picking up any shell casings, without getting rid of any weapon, and without concealing the body or doing anything like that. They want you to believe that the calm demeanor that they describe on the first call is his demeanor even after he's stood over this body and he knows he shot this person. He's calm. But somehow later when he's on the phone with dispatch, he's upset, he's distraught, he doesn't know what to do. I'm just asking you to consider whether any of that makes any sense when we look at the facts on the ground. And it does not. It makes absolutely no sense for this man, if he wanted to go out and shoot somebody, to call law enforcement right before he does it, speak to law enforcement right after he does it, right after he knows he did it, and then bring them back after he knows that they couldn't find the body because they didn't do a thorough enough search. None of that makes any sense when you look at the facts on the ground. What does make sense? Mr. Kelly sees a threat. He sees people with rifles. He calls law enforcement. He goes outside. He fires his warning shots exactly the way that he describes. He sees people moving from left to right. He turns in this direction to the right to fire over that tree that you all saw. Meanwhile, the body's discovered over there. It makes sense that Mr. Kelly did not fire any shots through that thicket in that direction. It makes sense that those shots were fired in the exact direction that he said that they were shot. And it makes sense that he continues to communicate with law enforcement. It makes sense that he's not distraught at this point. Why? Because he has no idea that there's a body there. In fact, we don't know that there is a body there when he calls law enforcement on that first call. It makes sense that he's telling law enforcement what happened and what he saw, and he's continuing to communicate. When he talks to the sheriff's department later, after he's discovered the body, it makes sense that he just discovered the body because of his demeanor in that phone call with the sheriff's department. He is upset and disturbed in a way that he was not earlier on in the day. All of the facts that we know make sense with Mr. Kelly's version of how things happened. They do not make sense with the state's version of how things happen. Nobody deliberately shoots a person right after calling law enforcement for help. And nobody, if they do that, which they don't, nobody lets law enforcement search their property, fail to discover the body, and then call them back later without taking any steps to conceal anything. Nobody does that. That makes absolutely no sense. Wanda Kelly probably picked the best word to describe that scenario, and that is crazy. Nobody does that. The standard in this case, we talked about this at the beginning, is proof beyond a reasonable doubt. This table has that burden. This table has no burden whatsoever. We do not carry any burden of proving to you that George Allen Kelly is not guilty. The state carries the entire burden of proving to you that he is guilty. And I mean proof. And in order for you to find Allen guilty of any of these offenses, whether it's second-degree murder or any of the lesser includeds, manslaughter, negligent homicide, they have to prove to you that Alan shot this person. And they have not done that. The ballistics don't prove it. The witness statements don't prove it. Alan's own statements don't prove it. The facts on the ground do not prove it. They haven't done it. In order to prove the offense of aggravated assault against Daniel Ramirez, Daniel specifically, they have got to prove that Daniel was actually there. It's as simple as that. They cannot prove that Daniel was there. Anybody who is on Mr. Kelly's property, and you folks were all on Mr. Kelly's property, there is no chance that you could describe that property the way that Daniel described that property. This is not the house with the pine trees that is maybe west of Nogales, maybe east of Nogales, he changes. This is not the house where there's a border patrol road that goes directly to the end of the wall. This is not the house that's either 2 football fields away from the wall or 15 meters away from the wall. That is not a description that anybody could offer of this area who has been there. The only conclusion that can be reached based on Daniel's description of this property is that he wasn't there. And that's just the property. He describes other things too. He describes being 10 meters away from the house when this happens. There is no body that is 10 meters away from the house. That is not possible. He describes the house being on his left. I'm facing south. That puts him to the west. The body is located to the east. Again, not possible. Daniel describes the shots coming from away from the house, towards him and Gabriel. Not possible. You cannot find Mr. Kelly guilty of aggravated assault against Daniel because Daniel was not there. And you cannot find him guilty of any of the offenses, second-degree murder or lesser included, because they did not prove that Alan shot this person, and they have to prove it. Your jury instructions have various justifications. You're going to read about the defense of premises and what's required by law to allow somebody to defend their premises and what steps they can take to do so. You're going to read about self-defense, using physical force, using deadly physical force, and defense of third persons. All of those jury instructions describe what somebody can and what they cannot do when they're confronted with a threat. In this case, if Alan is telling the truth and his is the only version that makes sense with the physical facts that we know and that we're not guessing about, he was confronted with a threat right outside of his home. That was a threat to his life. He had a rifle pointed at him. Under any scenario, he is absolutely justified in using deadly physical force to respond to that threat. He didn't use deadly physical force. He fired shots up into the air, over the tree, over where these people were, to get the threat to stop. And as soon as they turned and went the other way, he stopped firing. He didn't empty his magazine. The state's going to tell you that just firing warning shots is reckless, and just because he did that, you should find him guilty of something. That's not what the law says. The law does not say that you cannot use lesser force to defend yourself. The law does not say that when you're out in the middle of nowhere, and you folks were out there, this is not downtown Nogales, this is not a populated area, this is isolated, it is empty. He can fire warning shots to protect himself and to protect his wife. And that's exactly what he did. That's exactly what any man who cares about his wife and his home should do in this situation when faced with the threat that he was faced with. The jury instructions are going to explain to you that the state, besides having the burden of proving that Alan is guilty, they have that burden, They have the burden also of proving that Allen did not act with justification. It's up to them to prove it. It's not the defense's job to prove to you that Allen was justified in his actions. It's up to the state to prove that he was not. And we ask you to hold them to that burden. I told you at the beginning this is a criminal case. The burden is serious. This is dead serious. And the reason that we have this serious burden of proof in a criminal case is because we really need to know before we hold somebody criminally accountable, before we go burn somebody at the stake, we have got to know that they are guilty. We can't just have suspicions. We cannot be guessing. We cannot hope that this happened because then maybe this does justice here. No. We have to absolutely know beyond a reasonable doubt that this man is guilty. That burden really requires that you folks are biased in favor of the defendant. If there are two possible interpretations of different pieces of evidence, the defendant gets the benefit of the doubt. That's how the system works. That is how we know. You don't want to do something to the wrong person. Justice is not served if the wrong person is held accountable for somebody else's act. It's certainly not justice for Allen to hold the wrong person accountable, and it's not justice for Gabriel to hold the wrong person accountable for his death. Think of the burden of proof like scales. Scales balance like this. We start, the defendant is down here. He has the presumption of innocence. His scale has all of the weight. It is up to this table, it's up to the state to put weight into this other scale so that they're supposed to show you enough evidence that'll move it down, not so it's even, not so it's a little bit this way, but so their case is all the way on the floor and the defendant is now up here. That's the level of evidence that is required. And if they don't meet that, which they did not do in this case, then it's your job to find Mr. Kelly not guilty of these offenses. We want you to make this decision based on the facts, the known facts of the case, not based on subjective guesses about what somebody's words might mean, not based on, let's pick a small line in a transcript. Here, convict him based on this. No, that's not what this burden does. We are not permitted to just cherry pick somebody's words, decide what they mean subjectively, and convict a person because of that. You need facts. That's guessing, that's speculation. You can't guess or speculate. You need facts. And those facts have to be proven to you by this table. I wanted to remind you all again that we're not here to solve the mystery. If you sort through all the facts, you look at all of the evidence, you talk about it, and if you decide, I am not sure what happened here, we don't really know what happened here, that means the verdict must be not guilty. That is what that means. And the fact is, we're probably never going to know what really happened to Gabriel. And we won't know because the investigation in this case jumped to conclusions. They didn't search when they should have. They didn't preserve evidence that they should have. They didn't do tests that they should have. And now we'll never know. And when that's the case, when now we'll never know, that's a not guilty verdict. I just wanted to sort of leave you with what reasonable doubt is. It's not proof beyond any doubt whatsoever, but if you have real questions in your mind, if you're thinking, I just don't know, maybe he did, maybe he didn't, there's some evidence to suggest he did, there's some evidence to suggest maybe we're wrong about that, and then there are a lot of question marks and a lot of gaps over here that we don't know. The answer is a not guilty verdict. And if you're sitting back there in the jury room and you have those doubts, even if everybody else is all on board, if you have those doubts, then our system requires a not guilty verdict. We're asking you to have the courage to say no. It doesn't matter if there are any pitchforks or torches or anything involved. If there is doubt in your mind about whether Mr. Kelly did this, you have to have the courage to return a not guilty verdict. If there's any uncertainty at all. And they have to prove it. And I'll just leave this with, we talk about reasonable doubt a lot as lawyers. If there ever was a case where reasonable doubt existed, it is this case. If you put this case into an algorithm and asked a computer, does reasonable doubt exist? The answer is yes. We all live in Santa Cruz County. I live in Santa Cruz County. You folks live in Santa Cruz County. Otherwise, we wouldn't be here today. After reviewing all the evidence in this case, if I were to imagine finding a body on my property someday, hopefully that never happens, but if I ever find a body on my property someday and I don't know what happened and I don't know how it got there, I think I'd be considering my options before I called these guys. Thank you for your time.
Thank you, Counselor. State's rebuttal argument.
You gotta plug it in. Is it on? I do have a voice screen. There you go.
Thank you for waiting.
There you go.
You can go ahead.
Thank you. Well, we just heard that the state has this burden. Of course we have this burden, and we would have it no other way. And the defendant does get the benefit of the doubt. We would have it no other way. It's up to us to prove to you, beyond a reasonable doubt, the defendant committed second-degree murder or a lesser included an aggravated assault with a deadly weapon. We welcome that burden, and we welcome that responsibility. Defense just talked about looking at the facts of a case, and we encourage you to. There's the exhibits, there's the recordings, there's a defendant's interview, everything, call logs, everything. Review it, take your time, massage it, marinate over it, do whatever you need to do. We encourage that. I agree. We shouldn't guess just the facts. You must evaluate and decide. From the stand only, no other evidence of what he's thinking. There is no evidence, no one had a mind-reading cap of what the defendant's thinking. The only evidence you can consider is from that stand and what has been admitted as an exhibit. Attorney arguments of what the defendant is thinking or not thinking is not evidence. In shock, I'm just going to address a couple of these things. In shock, defense counsel likes to say the defendant was in shock when he found the dead body. Daniel was shot at with an AK-47 9 times, and his friend died before him. In shock. Talk about the porch door slamming. No evidence from the stand. None. The porch door slammed and made a sound. Additionally, you were out there. You walked from the living room to the outside, and did you hear a porch door slam? No, you didn't. Security sweep versus search of the property. You heard testimony from the officers. Difference between a security sweep, active shooter going out there making sure, one, preservation of life, making sure they locate Mr. Kelly, and two, find the shooter. It's all over after that. There's no searching of the property because no one knows anyone got hit. There's no searching the property except for an active shooter or the defendant to make sure he's okay. Wanda, on the stand, said these two individuals, Gabriel and Daniel, were walking by. They were walking by. Time of death, Sergeant Rodriguez said, pronouncement of death 6:24. Death, of course, happens before that. The shooting event is at 2:30. Death happens at 2:30. The view, the shot, the direction, the injury. Look at all the evidence. You saw the view, you know he shot, you've got the direction, and we have the injury. Don't guess, just the facts. I agree. Who is Gabriel? They have a photo of him a week and a half earlier, meaning nothing. We know nothing about Gabriel. You guys can't speculate if he's a hunter, he's out there sightseeing, bird hunting. We have no idea what he's doing. And on the day of January 30th, he didn't have binoculars. There's no evidence of him having binoculars. He does have a radio. That's not uncommon for migrants coming into the United States to coordinate pickups once they come into the country, to communicate with a driver to get picked up. That's not uncommon. And then they said a guilty person wouldn't do X, Y, and Z. Well, the defendant lives on a property where BP couldn't tell us how many, but we do know there's a lot of cameras out there. So imagine the defendant shooting someone and proceeding to dig a grave to put a body in. He's going to be caught on film. Of course he's not going to do that. Daniel, consistent in AK-47, consistent on a red horse, consistent on the position of Gabriel when he was shot. Not possible that he was there? None of this information was known. Except Daniel, when Daniel comes in and tells us about it. His reported false name, he owned everything. You heard on the testimony, he came in from Honduras to Mexico, and that's the name they gave him when he was a boy. And he's never hidden that fact. He took a guilty verdict, conviction in federal court with that name. He never once hid from that fact. I want to talk about this because defense counsel argued, the defense counsel argued, I might have to shoot back. That's not what he says. He says, I'm being shot at, I'm shooting back. He doesn't say, I might have to shoot back. He says, I am shooting back. Some of you guys may be familiar with Occam's razor. Sometimes the easiest answer is the right answer. Right? We've got two options here. This tale of 5 armed men, bandits, walking the property, shooting, not shooting, dangerous, not dangerous, backpacks, non-backpacks, or what the facts say. Defendant sees 2 guys walking his property, unarmed, goes on the patio with his AK, no warning, and shoots 9 times, and hits Gabriel on the side. Sometimes the easiest answer is the right answer. We just went through this. This is the toughest job you'll ever have. It will. It is. This isn't about the character of him as a person. It's not. We're not making a judgment call about him and his life. We're not. This isn't judging his life. This is about the conduct on January 30th, 2023, and that's it. Just the conduct on January 30th, 2003. How many windmills do we chase? How many? Do we chase armed gunmen? There's no BP footage, no foot traffic, no other shell casings found on scene. No one heard the mysterious shot. No evidence of drugs, guns, backpacks, a struggle, body dragging, blood trail. No evidence of any of that. None. No evidence of a rip crew. How many windmills do we chase? When the answer is obvious. If your goal is to get trespassers off your property and they are already moving off your property, question, why shoot? If your goal here is to warn off cartel members who are already moving off your property, if this boogeyman up to 15 members with guns, the question is, why shoot at them? And finally, if your goal is to protect yourself, and if someone points a gun at you, why are you shooting in the air then? If someone points a gun at you, why are you shooting in the air? Shoot back. Leugin, BP agent Morcel. Defendant said to Morcel, who told him, I struck something. You remember the testimony on the stand when they tried to cross-examine him about something different? And Agent Leugin said, that's the first time I heard that. He testified. Defendant says he was told by Morcel, I struck something. Remember defense opening, where they claimed Detective Ainza was hostile. We heard it today, that they browbeat the defendant. No such thing happened. Professionalism. Ainza first starts out by telling me, question, tell me everything you know. Very open-ended question and sat quietly. You have the interview. If you don't believe me, watch it. He asks them, anything you want to ask, anything that is important that's going to help out and assist me in clearing this out. Defendant responds, I don't know. I think we've been very professional, Ainza, and I thank you. I haven't been disrespectful to you. His answer is no, you haven't. There's no browbeating going on here. Ainza, I'm not here to disrespect you. I haven't been disrespectful. Question. Answer. No, you haven't. When they leave that interview, they handshake. There's no browbeating here. It's a voluntary statement by the defendant. Ainza, is there anything else you'd want to answer? Is there anything else you want to tell me before we end? I'm thinking. He's asking open-ended questions to the defendant. He wants to get to the bottom of this. Justification instructions, we saw this. There's 5 of them. Remember, it's a reasonable person standard. It's not the defendant's standard. It's a reasonable person standard. No evidence of any armed gunmen, no BP footage, no foot traffic. We talked about this. No one heard the mysterious shot. No evidence of a robbery, dragging, anything of the sort. None. There's no justification seeing 2 armed gunmen walking 2 fences away, 115 yards, pulling out your AK-47, stepping on the patio, no verbal warning, and shooting 9 times. No justification for that whatsoever. Important 2 concepts. We just talked about reasonable person standard. He escalates the situation. His wife is fine. She testified. She didn't grab her gun. She didn't lock windows. She didn't lock doors. There's no danger here. Justification. You do have the right not to retreat. You do. We don't argue that. However, you do not have the right to use deadly physical force to protect a person who didn't need protecting. And you don't have the right to use deadly force when there is no threat to home or yard. And you don't have the right to initiate, instigate, or escalate with deadly force. No right whatsoever. Reasonable doubt, we just talked about that. Leaves you firmly convinced. We don't know everything with absolute certainty, but it leaves you firmly convinced. Use your common sense and everyday judgment. It's not a mystical thing here. Firmly convinced, and nothing is known with absolute certainty. Use your best judgment. No guessing, just the facts, and we'll end with this. Gabriel and Daniel were shot at. Gabriel is dead, killed by a high-powered weapon, an AK-47. Entry wound, exit wound, lined up with the defendant's property. Defendant's words, and he's a typo, inconsistent with the physical evidence. Inconsistent. The victim's statements, consistent. Steps out, no verbal warning. Defendant shot his AK 9 times. Shell casings prove it. Ejection pattern proves where he was standing. Position and orientation of Gabriel's body proves where the shot comes from. Find him, the state's going to ask you to find him guilty of second-degree murder. We also have, if you don't agree, manslaughter. If you don't agree with second degree or manslaughter, you can find him negligent homicide. And also find him guilty of aggravated assault with a deadly weapon. He manifested everything in this situation. He escalated it. And I'm going to leave with this. The moral of the story, again, is you shot and someone is dead. The answer is yes.
All right, thank you. That concludes the closing arguments. Ladies and gentlemen of the jury, I need about 5 or 10 minutes just to finish a verdict form. This is the form that I'll give to you when you go back to deliberate. You'll have to complete when you complete your deliberation. So I'm going to stay here. I'm going to excuse you. It should just take 5 or 10 minutes. I'll stay here with the lawyers. We'll excuse the jury, and we'll have you back shortly.
Please rise and give forward. Please rise.
Let Louis do that. You go do that. Thank you, everyone. You can have a seat. Jurors are absent. All right. We're just going to finalize the verdict form. Should just take a couple minutes, and we'll be right back.
Please rise.
All right, thank you. We're ready with the jury verdict form, and we can bring in the jury. ready to swear the bailiff?
Please rise.
Please be seated. The record will show the presence of all jurors, counsel, and the defendant. Ladies and gentlemen of the jury, this concludes the closing arguments. I now have two brief closing instructions to give to you. I'll explain the verdict form, then we're going to pick the alternates, and then you'll be discharged to go and begin your deliberations. Final jury instructions, two final jury instructions are as follows. The jury foreperson. When you go to the jury room, you will choose a foreperson. The role of a jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. 1, make sure every member of the jury is present during all discussions and deliberations. So in other words, there's no discussions, no deliberations unless you're all present, even if someone just steps out to use the restroom. You all have to be present. The jury person is to preside over deliberations and make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. All jurors should be allowed to state their views about the case and what they think the verdict should be and why. All members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. If you reach a verdict or verdicts, fill out the verdict forms and then sign the form on behalf of the jury. That's what the foreperson does. If the jury reaches a verdict, the foreperson will inform the bailiff. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict forms as well as any question forms that have been used. When you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. The case will now and is now submitted to you for decision. When you go to the jury room, you will choose the foreperson. He or she will preside over your deliberations. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and with the approval of the court. After you have decided on a schedule, please advise the bailiff. You are to discuss the case and deliberate only when all the jurors are together in the jury room. Do not discuss the case with each other or anyone else during breaks or recesses. The admonition that I've given you before and during the trial remains in effect when all of you are not in the jury room deliberating. After you're setting your schedule, I suggest that you next review the written jury instructions and the jury verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations, or should you wish to communicate with me on any other matter, please use the jury question form that we have provided to you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note, and I will consult with counsel before answering it in writing, and I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or after you have been discharged. All 8 of you must agree on each verdict. You must be unanimous. Once all 8 agree on a verdict, only the foreperson need sign the verdict form on the line marked foreperson. You will be given verdict forms, and I'm going to review those with you now. So, what happened to the overhead projector? Can I use it? What happened to that projector? Did we take it out? Yes. All right, let me have the break for him. Well, I was hoping to put it up here while I discuss it with the jurors. I didn't realize that, well, you don't have the one that I did, though.
I can email this to her. She can pop it up there.
All right, email it right now. I do want to discuss this. I want you to see it as I'm going through it. I'm sorry, I thought I had that projector's been up the whole trial. I just assumed it was still up there. All right. So he can email it to, all right, appreciate that, thanks. So while they're doing that, let's discuss something I was going to discuss with you after I went over the verdict form. Anyway, scheduling. As I said, we're going to pick the alternates. You're going to start to deliberate. We shut down the courthouse at 5 o'clock. So when you're still deliberating at 5 o'clock today, we're just going to excuse you for the day. You're not going to have to come back into court. I'll send the bailiff in, and he'll tell you you're excused for the day. Then you can set your schedule. We expect you to come back tomorrow and keep deliberating. You can decide what time to start. Court's open, the courthouse opens at 8 o'clock. If you want to start at 8:30 or 9, it's up to you, okay? So you'll be discharged for the evening tonight at 5 o'clock or before if you want to go home earlier. Set your schedule, let the bailiff know what time you want to start tomorrow so we can have security there to let you in and so forth. Then tomorrow, as you're deliberating, again, you can take lunch, go out for lunch from 12 to 1:30 if you want a break. If you want to eat lunch in, the clerk and the jury commissioner, he'll bring lunch in. Let us know, but you kind of got to let us know by like 10 or 10:30 because, you know, ordering and getting everything prepared, we got to start that process ahead of time. If you tell us at 11:30 or 12, you won't get fed until 2 or 2:30, the way things work. So let us know if you want to eat in and keep deliberating, or you can take a break from 12 to 1:30, whatever you want to do. Just let the bailiff know. As this instruction said, any questions or any comments, any communication between the jury and the court has got to be through the bailiff and has to be done in writing. Everything has to be done in writing. It should be a note either signed by the foreperson, or if any of you individually want to send a note through the bailiff. And as I said, I'll get it, I'll confer with the lawyers, and we'll come up with a written response. Exhibits. When you go back to deliberate, the lawyers and the clerk will be working here with the bailiff to put together all the exhibits that we'll bring back into the jury room. You'll have access to everything that was admitted as an exhibit at trial. Now, there's some things, obviously, we're not going to bring back there and just, so anyway, we're going to bring everything back there that I approve of for right now, but there are going to be some things we're not going to bring back there, but you can still have them. For example, the clothing, bloody clothing, coats, firearm, shell casings, those physical exhibits will remain here, but they are accessible, all right? All you have to do is write a note saying, we want to see the clothing, and someone will bring it in, and you'll be able to look at it, for example. Now, some things were admitted and electronically. There's some recorded statements, some videos, some 911 calls, and those are all electronic. Those are accessible to you as well. Just let us know what you want to see, and if you want to see them, then we'll have one of our tech people bring in a laptop computer. I think there's a television monitor on there, and they will play for you whatever you want to see. And then they'll remove themselves so you can talk and deliberate about it. So if you don't see something in the jury room, it's because it's just not appropriate to bring it in there at the present time. But if you want to see it, tell us, ask for it, and then we'll have it brought to you. All right? That's going to take a little while to get together, because with a lot of exhibits in this case, so it may take a half hour, an hour or so to get what we can bring back there to you. All right, how are we doing? Oh, there it is. Okay, great. All right, do you have that on your screens? All right, thank you very much, counsel, for helping out. All right, so this is the form of the verdict. We, the jury, duly sworn and impaneled and sworn in the above title action upon our oaths, do find the defendant, George Allen Kelly, on the charge of second-degree murder on January 30, 2023, as the result of the death of GCB as follows. All right. Thank you. Check only one. All right. So this is the charge, and count one of the charge against the defendant, second-degree murder. Check only one. Guilty, not guilty, unable to agree, or guilty. All right. Now, we have these lesser included offense instructions, lesser included offense charges that the lawyers have argued to you. The verdict form explains to you when you go to those and what you do with respect to them. Lesser included offense verdict on manslaughter. Manslaughter is one of the alleged lesser included offense instructions. It's a lesser included offense of second-degree murder. If you find the defendant guilty of second-degree murder, do not complete this portion of the verdict form. In other words, complete this portion only if you find the defendant either not guilty of second-degree murder or you are not able to decide. All right? Real simply, if you find the defendant guilty of second-degree murder, you don't go to the lesser included offense instructions. If you find the defendant not guilty of second-degree murder, or you're not able to agree, then you check not guilty or unable to agree, and then you go to manslaughter. All right? Everybody with me so far? All right, it's a little confusing, so all right. So, if you get to manslaughter because you found not guilty or unable to agree on second-degree murder, then we, the jury, impaneled and sworn the above title action and upon our oaths to find the defendant, George Allen Kelly, on the charge of manslaughter on January 30th, 2023, as the result of the death of GCB as follows. Check only one. Not guilty, unable to agree, or guilty. All right? Now, there's another lesser included offense instruction, and the second lesser included offense charge is negligent homicide. The jury verdict form explains to you how to deal with that. Lesser included offense verdict on negligent homicide. If you find the defendant guilty of second-degree murder or manslaughter, do not complete this portion of the verdict form. In other words, complete this portion only if you find the defendant either not guilty of second-degree murder and not guilty of manslaughter, or you are unable to decide on either of those other charges. Then you render a verdict on negligent homicide, the second lesser included offense instruction. We, the jury, duly impaneled and sworn in the above title action and upon our oaths to find the defendant, George Allen Kelly, on the lesser included offense of negligent homicide on January 30th, 2023, as follows. Check only one. Guilty or not guilty. All right? All right. May not have any questions about that now, but if you go back to the jury room and at some point, if you're not sure about what you're supposed to do with respect to these lesser included offense instructions, send out a note, and we'll come back in and I'll try to explain it in a better way or differently. All right? There's only one form of the verdict. That'll be sent back into the deliberation with you. Leave those copies of the final jury instructions on your seat. You're going to get a one final copy for use of all the jurors. Any questions about setting your schedule?
Judge, did you want to go over count two?
Oh, yeah, I'm sorry, count two, thank you. Sorry about that. Count two is straightforward. There's no lesser included offense instructions on count two. Count two deals with the separate victim, who is Daniel Ramirez. That's count two is aggravated assault with a deadly weapon. We, the jury, duly impaneled and sworn in the above title action and upon our oaths to find the defendant, George Allen Kelly, on the charge of aggravated assault with deadly weapon, January 30th, 2023, as a result of his conduct against Daniel Ramirez, guilty or not guilty. No lesser included offense instructions concerning that particular charge. Sign the foreperson with your name and your juror number and whoever the foreperson is, because we've protected the identities of all jurors, and that will be ultimately redacted from the final verdict form, so don't worry about that. All right. Now we're going to pick the alternates. As I told you, the way we do things in state court, we never know who the alternates are. There will be 8 jurors who will deliberate. We're going to pick 4 alternates. We have a very high-tech method of doing this, okay? And just to show you, so I believe in transparency, here's how we do it. All right, you ready? Yeah. This is our high-tech method of doing it. Well, there's always controversies about ballots and ballot, counting and stuff like. So let's just keep it low-tech, okay? So each of your numbers has been put on a piece of paper by the clerk. She's folded them up, and there's 12 little pieces of paper in here. I'm going to blindly pick them out, then I'll give it to the clerk, and she'll read the name of the first alternate. We'll pick all 4 alternates right now. If your number is called, just please remain in place because I have some final words and instructions for the people who will be alternates. All right? Very dramatic here. Okay. I get one. All right.
Juror 10. Juror 4.
Is that just one?
Yes. Juror 8. Juror 3.
All right. Jurors 3, 4, 8, and 10. Talked about this once before, but let me remind you. I'm going to excuse you in a moment, and if you have things in the jury room, you can go get them. And if you want to say goodbye to your fellow jurors, you can do that as well. The admonition that I've given you about not talking about the case with anybody, not doing any research, not doing any investigation, staying off the internet, staying away from all exposure to anything having to do with this case, is still in effect. It's in effect until we call you and tell you that you are released from the admonition. Remember what I said yesterday in response to the questions from one of the jurors. The reason that we do that is these 8 persons who remain are going to go and start deliberating. If one of them has some kind of personal issue, a health issue, a family issue, some kind of emergency, and we need to excuse the juror who's deliberating, then we're going to pick one of you from those, one of the 4 of you, just the way we did. We'll call you, and you'll have to come back and join the deliberations, and then we'll have to start all over, but that's okay. And this does happen. You can't predict emergencies or things like that. So it does happen that we have to call alternates and say, come back in, we're going to need you to deliberate. Once the jury has reached a verdict, you will be immediately notified, you'll be told that you're released from the admonition, and you'll be told what the verdict is. Any questions about that from the alternates? All right, before you go, I probably won't see you again, and neither will the parties. I just want to, on behalf of everyone here in the court, and I want to thank the 4 of you who served as alternates. On this, we have all talked about, informally among us, what a terrific jury this was, how much attention you paid, how engaged you were, and the great questions that you wrote. I just want to, it's been a tremendous commitment. I'm sure it's been a kind of an emotional experience for you. I hope you found it valuable and rewarding. I'm sure it's been stressful, especially with the admonitions and the controls that we put on you. I just want to thank you from the bottom of my heart for what you did. And I hope you learned something, and I hope you found it was a valuable experience. And if I don't see you again, my sincerest thanks for your service in this case. All right, I will say goodbye to your fellow jurors, and then I'm going to excuse the 4 alternates, and if the remaining 8 jurors will remain in the courtroom. So jurors number 3, 4, 8, and 10, you're excused.
Please rise if you report.
The remaining jurors, please remain in the courtroom. And then you stay here. And you can leave your notebooks in the jury room. Thank you. All right, please have a seat. And now I'm going to ask the clerk, Jose, come on over here. The clerk's going to swear you in. I'm going to ask the clerk to swear in the bailiff.
Do you solemnly swear that you will take charge of this jury that you will conduct them to a private and convenient place to inquire into the offense submitted to them, that you will not suffer any communication to be made to them and keep them until discharged. So help you God.
I do.
All right, thank you very much. All right, and we give the verdict forms to the clerk to be delivered to the jury. Anything else from counsel before I excuse the jurors to begin deliberations?
No, Your Honor.
No, Judge.
Ladies and gentlemen of the jury, you're excused to begin your deliberations. As I said, we'll excuse you right before. Yes, leave those there. Please leave those copies of the jury instructions there on your seats. As I said, you'll get a court final copy for your use among yourselves in the jury room. We're going to excuse you a little bit before 5 o'clock. Let the bailiff know what time you're going to come back tomorrow and what you want to do for lunch and all that. Any questions from the remaining jurors? Very well. Thank you very much, ladies and gentlemen. The bailiff can take you out. You're excused to begin your deliberations.
Please rise, people forward.
And the record will reflect that the jurors are beginning deliberations at 2:40 p.m. We'll deal with that now. Okay. All the jurors are absent. You can be seated. Counsel, if you would work with the clerk of the court and the bailiff to identify make sure that the exhibits that are admitted that are going to the jury room are consistent with your records of what's been admitted. And I think we pretty well know what's going to go back there and what's not going to go back there. If they, as I told them, if they want to see something that's in some electronic format, we'll let you know, but basically they'll tell the bailiff and we'll send somebody in there from either from security or the bailiff or a technical person to let.
They have a laptop prepared already in case they want.
They have a laptop, okay. Then, if there's questions and how do you want us to contact you? I really like to deal with the questions as quickly as possible. I know your office is a little ways away. Do you want to do it remotely? I really. Go ahead.
We were probably just going to hang out.
Oh, that's fine. All right, that's fine. If you don't, that's fine. If you decide to go back to your office, let us know so we can make
Will do.
arrangements. All right, anything else? All right, we'll be in recess, pending jury deliberations. Thank you.
Please rise, people forward.
All right, well, are you ready? Yes, sir. All right, very well. We're back on the record in State versus Kelly. We received a note from the jurors at 4 p.m. The county attorney's on the line. Defense counsel and the defendant are here in the courtroom. The jury's obviously not present. The note that I have is from juror number 1, and it's, is there an exhibit index for both the prosecution and the defense? So I'll hear what the parties have to say. My inclination is to give them an exhibit list and have the clerk prepare a redacted exhibit list just to show what's been admitted instead of showing everything that was marked and not admitted. And now Jose said.
I think that's perfect.
All right, now there's another note. They just told Jose they have another note. All right, well, let's deal with the first one. Do you have any issue with that, defense counsel? We'll show you the redacted list if you want to see it.
Yeah, my only question was, some of them were multiple photos. Were they just going to say photos, or how were they going to label?
Why don't we, if Ms. Hunley or Mr. Jetty, if you want to come over, she's preparing a list that just shows what's been admitted. so we don't send the exhibit list back there with, you know.
Sure.
So, all right, why don't you, all right, so can we get a transcript? Here's the other note, which just came in. I'm marking these for 18/24 at 4:07 p.m. Can we get the transcript of Dr. Tim's testimony? And that's from juror number 1 also.
There's no transcript. They need to ask a question, and you can't import court reporter.
All right, let's see. Now there's a.
It's going to work right now. They got to recall the testimony.
That was long testimony.
Yeah, but they just need to be told to recall the testimony, and there's no dispute, so.
Well, I know the court, I'm just looking for the rule. There's no transcript, but the court can have certain testimony read back to them if they can be more specific about it.
Yeah, if they have a specific question, I think the court can read back specific testimony.
Let me see if I can find the rule.
I'll look through this.
All right, so why don't we answer the first question first? Why don't I, this is about the exhibit index, why don't I just say, yes, one is being prepared for you and will be given to you as soon as it's available. Fair enough?
Yes.
That works.
Yes.
Yes, one will be prepared for your use and will be provided to you as soon as it is ready. Good? All right, I'll just write Judge Fink. 4:10 p.m. All right, so take this to them and then bring it back when they're done with it so we can make it part of the record. All right, now. What's that? Okay. Let me see that first. Thank you. All right, the clerk has prepared a redacted exhibit list that just show the exhibits that were admitted. Ms. Hunley, do you want her to, defense counsel are here in the courtroom.
We're on the way over right now, Judge. We're walking as we speak.
All right, why don't you run, thanks. All right, and then we'll wait for you to come over here. Why don't you run another copy, and then you can give this to defense counsel, and then the other copy we'll give to the state when they get here. And here's, let me give this first question. Mark that number 1, okay? And I'll mark this number 2. Okay. Here's the rule I was looking for. 22.3, repeating testimony and additional instructions. Repeating testimony. Ms. Hunley, are you still on the line?
Yes, Judge, we are. We're listening. We just have you on mute.
Okay, no, I just want to be, I just wanted to be sure you were still on the line. All right, repeating testimony, 22.3. If after the jury retires, jury requests that any testimony be repeated, the court may recall the jury to the courtroom and order the testimony read or replayed. The court may order other testimony repeated so as not to give undue emphasis to particular testimony. Well, let me tell you my preliminary thoughts, and then I'll hear from the parties as well. Dr. Kim's testimony was lengthy. I think my proposal would be to respond to them would be, there is no transcript, but if you're able to identify specific parts of that testimony that are of particular interest, the court would consider having that read back to you. But I'm not inclined to just bring them in and have them read 2 hours or whatever it was at the time. I don't know how long it was, but 2 hours more of testimony.
The state agrees to that, Your Honor. I think the court could, if the jury can identify what specific topics they need, that seems appropriate.
What are your thoughts, defense counsel? You can take a look at the rule. It's 23.3, subsection A.
Yeah, I think if we get something narrowed down by topic, then we could consider whether that would be feasible.
All right, let me see if I can come up with some language here.
Is this just states?
Yeah, there aren't any defense exhibits on that.
Oh, you don't have it? Give me a second.
There's no defense exhibits on there?
No,
It's all state, I think.
all numbers,
It's not, maybe I
no
should.
letters. Thought you were being biased. You're just kidding. Thank you. Ours is shorter than theirs.
Oh, there you are, okay. I'm just trying to craft a response with that. Hold on one second, okay?
Oh,
Let me
sure.
just finish this. All right, here's what I drafted in response to note number 2 about the transcript of Dr. Tim's testimony. I wrote as follows: Dr. Tim's testimony has not been reduced to a transcript, so no transcript is available. The court, however, may authorize the testimony read to you in open court. Dr. Tim's testimony, however, was lengthy. If there is a specific part of that testimony that the jury considers to be particularly important, the court would consider a rereading of that portion of the testimony if that is important to your deliberations.
No objection, Judge.
Any objection?
No.
All right, then I'll put Judge Fink. And that's at 4:18 p.m. Okay. Jose, so then take this into them again, let them read it. Hopefully, I try to print as clearly as possible, and then bring it back for filing.
State's reviewed the exhibit list you provided for the state and the defense, and we don't have any objection to those going to the jury.
Does that have the defense exhibits on it?
Two
Yes, it
lists.
does.
There's 2 separate lists.
Okay, let me, can you grab that? Let me see what you have there, just so I can look at it too, those 2 lists. That's all right. All right, thank you. Okay, so these are good. Counsel, that looks, are you good with that? All right. Print out another set, okay. They're probably writing their response, so. All right, so we've had, just to recap, we've had 2 notes from the jurors, one about 4 o'clock, one about 20 minutes later. The first note was requesting an exhibit list of exhibits that had been elicited, had been admitted in evidence, one both for the defense and for the state. The clerk of the court has prepared such exhibit lists. The exhibit list that the clerk keeps includes all of the exhibits that are marked and whether they've been identified or admitted or not. So the clerk's prepared a list of redacted list, which just includes all of the exhibits by number, date identified, date admitted, and a description for both the defense and the state, and the parties have reviewed those. So when the bailiff comes back, I'm going to have him take these lists and give them to the jurors. I have a duplicate copy, and I want to make this part of the record, so we have a record of what we gave to the jurors. How should we mark this?
We can just file it.
All right.
Admitted exhibits, Your Honor.
All right, so these are, I'm going to write something on top of these. I'm going to write response to jury note number 1. All right, so I marked both of these response to jury note number 1. I'll give these to the clerk, so that I'll be filing in for a record. All right, now you can take. Oh, okay. So they didn't write anything? No. Okay. All right, so there's no response on that, so I'll give that note to the clerk. You can take these into the jury. This is the response to the request for the exhibit list. Yeah, okay, so the jury has asked them to be excused for the day, so we'll do that. The second note from the jurors had to do with their request for the rereading of Dr. Tim's testimony. I wrote a response that says, basically, after having consulted with counsel, that there is no transcript of Dr. Tim's testimony. There's no transcript of any of the witnesses' testimony as far as I know, certainly not a final transcript. So I responded that there is no transcript of Dr. Tim's testimony. One has not been prepared, so one cannot be provided. However, if there's a particular part of Dr. Tim's testimony that is of particular interest and importance to the jury, the court would consider having them come back into court and have a rereading of that portion of Dr. Tim's testimony. Dr. Tim's testimony was very lengthy. I don't know, it was probably like 2 hours or so. So it's not feasible to read back the whole thing. But if there's some particular part of her testimony that they think is important, and they can identify that, then we'll consider having them come in tomorrow and read that. I suppose it would have been helpful to know that now. So
That's what I was going to say. If I could make a suggestion, I would ask that we give them that response before they go home tonight.
I did.
That way
I
maybe
did,
they
and they
can-
just sent it back.
Oh,
So
Oh.
they're on their way out. But yeah, so anyway, we'll find out tomorrow. Maybe we'll see what they say tomorrow. But
just thinking about Denise, so she could put it together.
she'll start working on it. I knew she would. All right, so we've excused the jury for the evening. I think Jose said they're going to come back at 8:30 tomorrow morning. All right, so I think you're all excused for the evening. Right.
Your Honor, can you order the exhibits not?
Oh, I'm sorry. I'm also ordering, as is usual, that any exhibits not admitted by either party, all right, any exhibits not admitted are to be retrieved by the respective parties and kept for in a secure place and with security for any future need. But the clerk doesn't keep any exhibits that were not admitted.
And just logistically, Judge, once we have the portion of the transcript, or however it is that the jury has identified it, how do we read that to the jury?
The court reporter reads it.
Court reporter just reads
Right,
it? Okay.
yeah. But
Just wondered if you needed us to bring people, or I just want to make sure we were prepared, whatever you wanted us to do.
I think the court reporter reads it because it's mostly a lot of it's off of her notes, too.
Okay.
What time did they say they were going to start tomorrow? 8:30. All right, so we're adjourned until 8:30. Just make yourself accessible. If you want to hang out at the court tomorrow morning, it's fine, too. Thank you very much. Then we're adjourned for the evening.
Please rise, por favor.
Thank you, people.